I will now call this session of the City of Issaquah Hearing Examiner to order. For the record, today is Tuesday, April 23rd, 2024 at 9:50 a.m. We have one item on the agenda today, case number APP 2023-0003, an appeal by Roberta Brown of a decision by the City of Issaquah to issue Administrative Site Development Permit number ASDP 22-00007, related to the Verizon SEA Providence Heights ASDP project. My name is Alex Seidels. I'm an independent hearing examiner whom the city has selected to hold certain land use hearings like this one. It will be my role today to collect evidence in the form of exhibits and testimony to determine whether the appellant has met her burden to prove by a preponderance of the evidence that the city issued the administrative site development permit in violation of the requirements of the Issaquah Municipal Code. To that end, I received and reviewed some 47 proposed exhibits in advance of the hearing. I received those from the appellant, from the city, and from the applicant for the underlying site development permit. In a moment, I will ask whether the parties have any objections to any of those exhibits being admitted. I also received the parties' pre-hearing briefs, which were very helpful to me in clarifying the issues I am being asked to decide. The order we will follow for the hearing is, first we will hear optional opening statements from the parties, beginning with the appellant and then moving on to the city and the permit applicant. Then we will move on to the appellant's witnesses, who will be subject to cross-examination by the city and the applicant. Then we will hear from the city's witnesses, who will be subject to cross-examination by the appellant. Then we will hear the applicant's witnesses, again with cross-examination. And finally, we will hear the appellant's rebuttal witnesses, if any, again with cross-examination. We will then hear closing arguments in the same order. Appellant first, then the two respondents, and then the last word will go to appellant because she bears the burden of proof. It was my hope to get this entire hearing done today. I realize we've lost an hour already, and if it is not possible to get it done today, we do have a second hearing day set aside on April 25th. In all circumstances, we will not go beyond 2 hearing days. So if we end up getting into April 25th, I will start to impose time limits on the parties. We will not be taking public testimony at this hearing, as this is an appeal hearing only, but members of the public are welcome to observe. So thank you all for being here. I always like when there's a lot of engagement with these hearings because this is land use. We deal with important issues that affect large numbers of people. I'll begin by having the parties introduce themselves to me, starting with the appellant, Roberta Brown. Do we have anyone here representing Ms. Brown, or is Ms. Brown herself present?
Myself.
I think I heard myself. Was that you, Ms. Brown?
Yes, it is.
Okay, thank you so much. And who is representing the City of Issaquah this morning?
I'm Anne Marie Soto, Deputy City Attorney for the City of Issaquah.
Good morning, Ms. Soto. And do we have anyone here from the applicant team?
Yes, Richard Bush, Bush Law Firm.
Okay. Welcome to you all. Thank you all for being here, and thank you again for your patience. I guess I'll poll the parties here, make sure that we don't have any procedural issues or issues related to the exhibits. So we'll start with you, Ms. Brown. Did my summary of what we were here to do track with what you were expecting to do today? And do you have any procedural issues we need to address?
I believe that it's what I expect. I assume
Okay.
when I introduce my witnesses, I will give them some questions.
Exactly. That's exactly right. And then when you're done questioning each witness, the other side will question that same witness. Then we move on to the next witness. All right, Ms. Soto, do you have any procedural matters that you want to address?
Yes, the city has 3 issues that we would like to address.
Okay.
So the first issue being the city would request that issue number 2 of the appeal be dismissed in its entirety. That is the issue dealing with stormwater and wetland issues. Ms. Brown did not address that issue in her brief. She specifically noted she was not addressing it. The one witness who was scheduled to testify from Ms. Brown's witness list to testify regarding stormwater was struck from her witness list. And so the city would request that that issue be dismissed in its entirety.
All right, I will not dismiss that issue at this time. Pre-hearing briefs were optional, and of course, the parties can make their cases without any witnesses at all. They could make their cases just based on the documents. So I'll leave it to Ms. Brown how much focus, if any, she wants to put on the wetlands. Maybe that's something she can talk about in her opening statement, or she could even save it for closing arguments.
Okay, next, the city has objections to 3 of the exhibits. First is exhibit number 16. There's no reference as to what that document was, where it came from, whether it was even considered as part of the Issaquah School District's MSP or SDP permits, or related to the ASDP that's actually at issue on this appeal. It appears to be a document that may have been submitted as part of pre-application materials, which are non-binding, and so the city would request that that be would be excluded from this hearing.
So the way I'll handle Exhibit 16 is if Ms. Brown wants Exhibit 16, she can put forth a witness explaining what it is and where they got it and what its possible relevance is. Because I agree with you, Ms. Soto, it doesn't, you know, it doesn't leap off the page as obviously relevant to the case, but maybe Ms. Brown's witness can clarify that. If she does not put forward a witness, we will strike Exhibit 16.
Okay. Just a question, is the hearing examiner going to have us just admit all of the exhibits at one time then, or do we need to introduce them with our witnesses?
So the dream was to admit them all at one time. Obviously, if you have objections, you're welcome to make them. So yeah, this is your chance to, I probably should have mentioned that in my opening. Yeah, I'm planning to admit everything unless there's an objection. So we've got a question on 16, but you said you had 2 others as well?
Yes.
All right.
Yes. So
any that you don't question, I'm just going to automatically admit here. We're not in court here. We can move a little more efficiently.
right. The other 2 exhibits are exhibits 30 and 32. It's unclear where these documents came from, and there's no context as to what they're related to. In particular, exhibit number 30, which is a document that's noted as FCC NEPA process. Unclear if this is some legally binding authority, where this came from. And so again, the city would request that those 2 exhibits be excluded.
Yeah, agreed. Not sure what the FCC NEPA process document even is. There strangely appears to be a picture of a warbler on it. I'm not sure what that warbler is going to tell us about this particular case. Exhibit 32 is at least it's emails to and from the city of Issaquah. Streamflow models are just that, models. It's from Larry Franks to various people associated with the Department of Issaquah. And the date on it is March 3rd, 2022. Yeah, maybe we'll have some testimony from Ms. Brown on that. So let me go back to you, Ms. Brown. You've been challenged on 3 of your proposed exhibits, 16, 30, and 32. I am neither admitting nor denying them at this time. If you want them to come in, you have to put forward a witness that explains what they are. You don't have to do that right up front. You probably have an order of witnesses that you were planning to go in, and you can stick to that order. But somewhere along the way, if you want these 3 exhibits, someone will have to talk to them. If you don't want those 3 exhibits, if your case can survive without them, then fine, you don't have to talk about them, and I just won't admit them. So that's how we'll handle that. All right. Any other issues for us, Ms. Soto?
Yes, the city had a few objections to witnesses as well. So first, with respect to witness Leo Graham, he is noted to be testifying regarding the law, and the city would object to any testimony concerning, quote, the law, as the city's municipal code and the permit decisions speak for themselves. The city also notes that this particular witness, along with all of the other witnesses, Tom Mullins, Minnie Dollywall, Christian Geitz, and Doug Yormick, are listed to be discussing potentially the ISD parent project, also Mr. Osmer. And the city would object to any testimony that's not directly related to the ASDP that is being appealed, including the status of the ISD overall project and any future plans or funding or financing that the ISD is is working on, because it is not relevant to the ASDP, and in particular the criteria for approval for the ASDP that's at issue. And then lastly, the city would object to Mr. Osmer's testimony as it relates to, and this is from the witness list, the ISD project on the parent property and future district plans as they relate to APP 23-00003. That is not something that is really relevant to the issue that's on appeal.
Do you know what 23-0003 is?
I do not.
All right. So I think what I'll do, on your first objection, Leo Graham testifying about the law, I agree with you to a certain extent. Generally, talking about what is and is not lawful is the job of the attorneys, or in the case of unrepresented parties like Ms. Brown, it would be Ms. Brown's job to talk about that. Someone testifying under oath should be testifying about the facts, not arguing about what is and is not legal. The question of whether something is legal or not is not a question of fact. It is a question of law. So generally speaking, that would be something for Ms. Brown to handle on her own during closing arguments. That said, it is very common, kind of sadly common in these land use proceedings that, witnesses, including city staff, will get up there and they say, well, the code says we have to do this, so this is why we do that, and here's why we think this complies with the code. I almost invariably allow that kind of testimony. So what I'll do is I'll let Mr. Graham testify. If it just, kind of goes completely off the rails and we're just hearing, argument about why he thinks that this project does not comply with the law, I'll stop him and ask that he save that for Ms. Brown. But, if he's here to talk about permitting processes or what have you, I'll probably allow that. So right now, I'm not going to hand down any rulings on Mr. Graham. I'll keep an eye on him, and certainly you can object if his testimony starts to go off the rails. With regards to the witnesses who intend to testify about ISD, Issaquah School District, I assume, and their future plans and the parent project, I will allow that testimony. We've got a master plan here. It's in, I think, Exhibit 33, was it? That's not right.
The decision is Exhibit 33.
Yeah, but where's the master plan? I was just looking at this the other day. At any rate, maybe it's in my notes. Yeah, so it is
13.
At any rate, whichever one the council decision is, that's what I'm assuming we're talking about with regards to the parent project. The parent project does, to a certain extent, control, some of the, lower decisions like this one that fall under it. So I do think we have to hear, what did the parent project say was going to happen? What did it say was not going to happen? You yourself in your own brief, Ms. Soto, repeatedly refer back to, site plans that were approved as part of the parent project. And you're like, oh, look, here's the cell tower shown right there on this site plan. So we certainly are going to hear testimony about the project plans. I agree with you that future plans may not be as relevant, but even there, I'm not going to draw a hard line. Several of Ms. Brown's appeal issues relate to the preservation of vegetation. And I think you had in your own brief that, vegetation is going to be fine. There's a landscape plan. Whatever trees have to come down will get replanted, in greater number than ever before. So I do think that the future plans matter. If your argument is going to be they're going to replant everything that got cut, then okay, now we're in the realm of future plans. So I think I do want to hear to a certain extent about future plans. I don't know what permit 23-0003 is either. We'll wait to see if the witness wants to talk about it. It may be relevant, it may not be, I don't know. But at this stage, I'm not willing to exclude any testimony. So I guess where that leaves us is Ms. Brown is on notice that I do have some skepticism about the relevance of some of this proposed testimony. I do have some skepticism about having a fact witness come up here and tell us his personal opinion about the law. But we'll see where things go. All right, anything further, Ms. Soto?
That is all. Thank you.
Okay. And Mr. Bush?
Thank
Any
you.
procedural issues for us?
No additional procedural questions or objections. Just for the collective, I do believe APP 23-00003 refers to this immediate appeal. It's not a new application, it's the immediate appeal.
Oh,
and
that's
if
our
I'm
case
incorrect.
number here.
Yeah.
That's our case number.
Yeah.
Didn't we announce that at the very beginning? Oh, I did. That's
Okay.
our yes.
Sorry,
Well,
I thought that was,
hear testimony about our own case.
Yeah. Well,
I thought
cheated.
that was a permit. Sorry about that.
Yeah,
Yeah,
I
right.
cheated. I looked at the appeal document as it was in front of me. So
Well, savvy
Got it, thank
lawyering
you.
here, Mr. Bush. Yeah, read the appeal document. Okay, great. So I think what we'll do is move into opening statements, which are optional if the parties wish to give them. Ms. Brown will go first. So Ms. Brown, do you have anything you'd like to say about your case?
Yes, thank you. And I'll begin by saying, when I wrote the list of potential witnesses, what I said there is not absolutely binding, so that word of law is, I'm glad to remove it. So thank you. Okay. My name is Roberta Brown. I'm a resident of Issaquah and the individual applicant for Administrative Site Development Permit, ASDP 22. I live in Providence Point, a 55+ residential community developed in the 1980s, comprising 1,008 units on 160 acres, and where approximately 1,400 people make their homes, which are modest, most people living on fixed incomes. The grounds are quiet, wooded, and well-maintained. In the interest of doing my part to help this hearing proceed as efficiently and focused as possible, especially given our delay, I will very briefly here present what I believe to be 3 overriding topics for our hearing today, all of which bear directly on the remaining issues in my appeal. I'm not sure if we need to get lost in the weeds, in fact. First thing I'll very briefly mention is a little more background for our hearing examiner to know about the area. Secondly, what I believe to be the principal legal basis for consideration in the appeal, some of which we've considered. And finally, some undisclosed core application related evidence disclosed just 11 days ago. First of those 3, a little background. This appeal is of a proposed development permit for possibly the largest macro tower wireless communication facility in our area, a facility that belongs on freeway on-ramps, off-ramps, or in rural or unincorporated areas. Yet, this proposed facility is within 20 to 30 feet of the property boundary of Providence Point. Its visual impact will entirely change the character, not only of Providence Point, but of the larger area, and for thousands of motorists who drive down 43rd Way, a major artery between Sammamish and Issaquah. The photo simulations for the project are entirely misrepresentative on many accounts. Further, the area of the permit is in the heart of Issaquah's Providence Point sub-area. A major portion of this sub-area comprises one of the city's renowned forested hillsides, which the city aims to protect with the goal of maintaining 65% canopy coverage. The city's related goal in growth-related and land use plans is for much of the 2% future growth approximate to occur in the valley in central Issaquah in proximity to main transportation hubs and employment opportunities. My second topic, rush, is my understanding that the legal basis for the contested Verizon project includes vested Chapter 18.04, vested Chapter 18.22, and other applicable municipal, county, and state regulations. A second important set of legal controlling documents is gathered under the file name PRJ 190008. This includes the complex set of legal controlling documents, including.
Can I jump in real quick there, Ms. Ben? Is that what you're referring to as the parent project, PRJ 19-0008?
And it's part of Exhibit 15.
Yes, I'm just asking, is that the parent project?
Yes, it is.
Okay, thanks. Continue.
Sure. This includes a complex 175-page staff report and the city council decision for the property owner's intent to build a high school, an elementary school, a large sports complex, including a 2,000-person grandstand and required parking. The biggest project in Issaquah in 20 years. Providence Point Homeowners Association borders 3 of the 4 sides of this 40-acre school district site. Long negotiations between the school district, the city of Issaquah, and neighboring residents went into the design of the school project with the successful objective of preserving a substantial buffer the entire length of the school perimeter that borders Providence. Finally, my third topic. On March 29th, a license agreement was submitted as exhibit number 46. This by the new legal representative for the Verizon project, Mr. Richard Bush. This document is important for 4 reasons. First, it is between licensor Mr. Jake Cooper, Chief Financial Officer of the Issaquah School District at the time, and Gordon Cook of Verizon Wireless. Second, the agreement is for up to 2 temporary 85-foot cell towers, in clear contradiction to the permanent 150-foot tower that we find in my appeal ASDP 22. Third, according to its stipulations, the agreement appears to have gone into effect March 2022, with the possibility of a 2-year extension. So it expired March 2023 or renewed on March 2024. It has thus expired. As a result, the applicant has no legally bearing agreement for use of the subject parcel and no easement for vehicular access. Proof of the vehicular easement is still required before the appeal permit can be granted, as stipulated in condition 1 of the height variance decision. My 4th point, final on this one, is though drawn up October 21, it does not appear anywhere in the controlling school project documentation, nor was it disclosed during the height variance hearing for the Verizon C project at a time when it was likely still in force. Nor is there any reference to its content or existence in any of the subject administrative site development permit documentation, nor in the appeal documentation, including core exhibits and the applicant's motion to dismiss my appeal. What we appear to have is a case of long-term, intentional non-disclosure of a core project application document. In conclusion, with this new evidence, together with violations of code and conflicts with the controlling school project permits, as I have presented in the appeal and pre-hearing brief, I ask the hearing examiner to consider either vacating ASDP 22 or remanding the permit to the city for further consideration. The applicant can come back when the Issaquah School District has a better sense of what will happen to the property. Following the results of a bond, I understand the district plans to submit to voters in November. Finances being a very serious consideration for this development. Meanwhile, the existing WCF on the water tower functions with equal propagation to what is expected on the proposed new 150-foot macro tower, according to Peerline Solutions radio frequency review. That is Exhibit 8. So we don't even need this whole project. We're here. I don't know why. Thank you very much.
All right, thank you, Ms. Brown. What are you going to do with regards to issue number 2 of your appeal, wetlands and stormwater? Is that something that you are interested in presenting evidence and argument on, or are you dropping that issue?
I believe it still is a very strong issue. However, I'm interested in saving time here. And so I think the evidence that is given is sufficient to show that the issue stands as a reason for the appeal. I would be glad to bring it back if there's need for a written final statement, but that's my sense.
I'm a little bit confused about your answer. If you're planning to argue wetlands and stormwater, you know, we have a lot of evidence in the record already. All but 3 of the exhibits have already been admitted. So I think what I'll do is this. If you want me to hand down a decision on wetlands one way or the other, you can mention it during your closing arguments. If I don't hear it in your closing arguments, then I'm going to conclude that you've abandoned that issue. So the ball will be in your court as to whether you are arguing that issue or not. Okay?
Can I ask you a question?
Yes.
By abandoning it, do you mean that it would not figure into your final decision?
Correct. So you filed an appeal with, I think, like 7 or 8 issues. 2 of them were dismissed in my pre-hearing order, so those will not be a part of my decision going forward. I'm now asking you what we want to do about the wetland and stormwater issue, which we've been calling issue 2. Do you want that one to be dropped such that it will not be part of my order, or do you want an order on it? That's what I'm placing in your court. And I don't really understand your answer that you've given me now, so I'm telling you what I'm going to do, which is, if you put some argument about it in your closing arguments, I'll give you a decision. If you don't put it in your closing arguments, then I will assume that you have abandoned it.
Okay, thank you for explaining that. I'll wait for the closing argument and decision.
Okay, so I think next we were going to hear from the city. So Ms. Soto, optional opening statement.
The city does not intend to make an opening statement at this time.
All right, Mr. Bush, opening statement for the applicant.
Thank you, hearing examiner. The only opening statement I have is the recurring theme here is the timing of when information needs to be submitted to the city of Issaquah in order to proceed with the development project. There is a variety of issues on appeal. There is extensive comment about the license agreement. These are all items that are relevant to the final construction of the project. The underlying question is, at what time under the Issaquah Code are these documents to be delivered to the city? So the evidence you'll be hearing today from the applicant is, first, what information is available, and second, when is it due? And then turning back to focusing on what is deliverable as a part of this ASDP decision that's on appeal. So that's kind of the overarching theme that we're going to be presenting today.
Gotcha. Thank you. That's helpful. One question I guess I have, this is maybe for all parties. No one needs to talk about it right now, but this is something I hope you'll discuss during your closing arguments. We do have a master site plan here. That's what Ms. Brown was referring to as the parent project. It's the council decision on the overall plan to build the schools. In terms of, my decision criteria here, the code does have decision criteria for an administrative site development permit. They're very limited, and this has been the subject of some argument in pre-hearing motion practice already. You've got these kind of like narrow handful of issues that the hearing examiner is allowed to look at for an ASDP. Okay, fine. But we also have the master site plan here, and once a master site plan is approved, I think it, to some extent, governs subsequent land use approvals, right? So like if the master site plan, for example, says you will not cut one single tree or even a blade of grass anywhere on the perimeter of the project, right? It doesn't say that, but let's say it did. And then here you are building a cell phone tower on the perimeter of the project, in flagrant violation of this hypothetical condition in the master site plan. Would that be grounds to deny? Or do we say, it doesn't matter what the master site plan says. The only thing the hearing examiners are allowed to look at are the ASDP, decision criteria, and they don't say a word about preserving every blade of grass. So just ignore what that MSP says and just focus on those decision criteria. I'm a little bit unclear about which way the parties would like me to go.
I'll defer to the others first.
Yeah,
Yeah, I'll defer to the others first.
I was going to say later, but what do you got?
No, I mean, again, it's a part of the underlying theme here. I'll defer to the appellant and to the city first.
All right. So maybe I will hear from you, Ms. Brown. I told everyone we'd do this in closing, but now I'm interested in it. So, Ms. Brown, when I write my decision, am I just looking at the ASDP approval criteria in the code, or do I also have to comb through this master site plan, looking for rules that it has set, and then trying to find ways that this cell tower violates those rules? Which is the correct approach?
The correct approach is that you must look at the master site plan.
What is your basis for saying that's the correct approach?
Because it is the master site plan by the property owner for the property that includes the parcel on which the WCF facility is proposing to build.
Well, I know that the master site plan is the master site plan. That's why it has the name. But what's the rule that says everyone has to obey the master site plan, including the hearing examiner? Where is that rule?
That rule, you yourself asked where that was.
And now I'm asking you.
And why it wasn't in the core.
And the reason I'm asking is, does it even exist? Is that really
Yes.
Where? Okay, if it's the rule, it's written down somewhere. I need to know where. So that'll be, it doesn't sound like you have an answer right this second, or maybe we'd have heard it already.
No, I believe, yeah.
All right, so maybe we'll come back to that in closing.
Back to one thing, there is a rule that the property owner does have to agree to something like this. So in any case, I'll leave it.
We'll maybe hear a citation to the rule during your closing arguments. Ms. Soto, any thoughts on this question of mine? Am I just looking at the narrow ASDP criteria, or do I have to read the MSP and make sure that these lesser permits remain in conformance with it? What's the process?
So you'll hear testimony from city staff about what the purpose of these different types of permits are. And the MSP and the SDP for the Issaquah School District project is really looking more at general conformance with the city's municipal code, but it's not until the other permits that actually carry out that project are reviewed where the city gets into the details as to whether what they're specifically going to be carrying out meets those requirements.
So my hypothetical there, Ms. Soto, is what if, MSP condition approval number 1 says you won't harm a single blade of grass on that perimeter, and then we get a lesser permit, an ASDP, that says, oh, we're going to put a cell phone tower up in the perimeter and harm lots of blades of grass. Would the violation of the no blade of grass condition of approval be grounds to deny this lesser permit?
No. So you'll hear testimony that there are provisions in the code to amend an MSP and an SDP. There can be either major or minor amendments to those things. Again, you'll hear testimony from the staff about what the purpose of these different types of permits is, including the purpose of an ASDP. The ASDP is really looking at how is the site going to be designed. It's not the final construction permit that really hones in on what specifically will be done on the property. If there is something that was in the MSP that says you cannot do XYZ, and a later permit says, well, we are going to do XYZ, the MSP can be amended. It goes through a process that is either an administrative process or a more vigorous process, depending on what type of amendment it is, whether it's major or minor.
So what am I supposed to make then of the language in, and I think this is the correct citation from the former code, 18.04.520, upon city council approval of a master site plan or development agreement, the property's development shall be governed by the substantive provisions of the approved plan/development agreement and implemented through subdivisions, short plats, binding site plans, or other applicable permits in accordance with the procedures specified in the plan/development agreement. Doesn't that mean that if the MSP sets substantive restrictions on development, all other permits, including ASDPs, have to follow those restrictions?
So you'll also see in that same section, I'm pulling it up right now, there are provisions for amendments of those master site plans. So in 1804-530, there are provisions for major and minor amendments, what the process is, what they do, what types of changes can be made. So you have that. In addition,
Well,
there's a condition of.
Wait, we've got to go a little slower than that. So I understand that MSPs, unlike some types of permits, can be amended after issuance. I don't know that there's anything in our record that says the the MSP that the city council voted on has been amended. I'm not aware that anyone has done that. Are you?
I am not aware at this time. We might hear testimony regarding that. But again, the purpose of the ASDP, as staff will testify, is to essentially, and I don't want to speak for staff, they're the people that should be really explaining this, but they're looking at whether or not this site meets the criteria for siting and design outlined in the code. The other, if that is approved, and if it requires an amendment to the MSP, depending on what is approved, then the school district can go through the major or minor amendment process as part of that.
I think that's it. So then to get back to my hypothetical, if condition 1 of the MSP says don't harm a single blade of grass, and then we get an ASDP for the cell tower that harms lots of blades of grass in violation of the MSP, staff could look at that and be like, oh gosh, we violated the MSP. Luckily, we can go back and fix the MSP to kind of ratify this plan we have to do the cell phone tower. Is that kind of what you're spelling out here?
Yes, and there is a condition of approval in the ASDP that it still has to comply with the other permits. So we have that. In the MSP itself, there's also a condition that talks about, I think it's condition number 5, that talks about how other permits are reviewed for conformance with the MSP and SDP.
Okay, all right. So maybe we'll hear some argument on that. Ironically, Ms. Soto, it sounds like you're planning to put on city staff who are going to hold my hand through how the code works and all that stuff, and yet you were objecting to the idea that there would be a testimony from Leo Graham on what basically sounded like the same thing. So as I said, in these hearings, we always end up hearing from city staff who are like, code provision A says this, and that's why we do this. It's all testimony about how the law works. So, I just bear that in mind when you start thinking about objecting to other people, doing that same thing, because it just happens. All right. That was a pretty good answer, Mr. Bush. Your thoughts? Do I hold everyone to the MSP here and reverse your permit for violations of the MSP, or do I only reverse your permit if I can find a violation of the ASDP approval criteria in the code?
Okay. What I'd like to do is address your question as a process question in this appeal, because what I expect, and I've got a scorecard here from the process, because the appellant has the burden of proof, I expect the appellant to come in and say, section 2.2 of the MSP says X, like don't harm any blades of grass.
Okay.
Section 5.5 of the ASDP says mow every blade of grass within a lease area.
There you go.
I haven't heard any of that from the appellant. There is zero evidence in the record of any term in the MSP that is violated by the ASDP. It is the appellant's burden of proof to come in and point precisely to what the requirement is that is being violated by a particular section of the ASDP. So I see it as a process question.
Well, you're right about that, Mr. Bush, and certainly, no one here is going to make the appellant's case for her. I warned her of this in one of my pre-hearing orders, in about as strong language as I could possibly come up with. The appellant has to tell us what she thinks the rules are here and how exactly those rules are being violated. Vague allusions to, the parent project are not going to cut it. But let's say she does that. Mr. Bush. Let's say she, puts forward some kind of argument that says, MSP condition 1 says don't hurt the grass. ASP condition 5 says hurt all the grass. If she puts on a case of that strength, what should I do? Should I say, no, MSPs don't control my decision. My decision's just, the ASDP approval criteria, and they don't mention MSPs. Or do I say, oh no, MSPs are actually controlling documents, and if you violate the MSP, then that's grounds to reverse your lesser permit?
Yeah, I think the city has explained that there is a condition in the ASDP requires us to comply with all the other permits. So the answer is, in my mind, is a remand to reconcile the difference.
All right, let's take, where's that condition? I have the ASDP called up here.
I'm going to have to call it up.
Yeah, I know. We're getting like way ahead of your typical opening statement, but I'm hoping.
Yeah, I kind of forgot this is opening
like
statement.
A cleaner hearing that like talks about issues that are actually interesting.
Yeah. So what I'm trying to do is frame the discussion to come. So I'll be listening to the appellant's comments for the precise section of the ASDP that conflicts with the MSP.
Right.
So I can keep track of it and go back and find all these different sections. So I haven't gone through the ASDP at this point to find what it really says.
No,
I don't have the answer to your question.
And you can always hope that appellant puts on a weak case and you don't have to, deal with any of this. But, it's in my mind. So, all right, well, I won't torture you anymore with this. Okay, so that was kind of longer opening statements than we thought. Let's turn now to appellant. Ms. Brown, you may call your first witness.
Okay. Very interesting. Thank you. My first witness is Tom Mullins of the Issaquah School District, and I hope Tom is still there. Thank you.
Mr. Mullins, are you with us?
Yes, I am.
All right. Good morning, Mr. Mullins. I'm going to swear you in as a witness. Will you raise your right hand, please, sir? Do you swear or affirm the testimony you give in this hearing will be the truth?
Yes.
Thank you, sir. And I see the spelling of your name on my screen, Tommmullins. Is that spelling correct?
Correct.
And what is your association with the Issaquah School District?
I'm the Director of Capital Projects here at the Issaquah School District.
Okay. All right, Ms. Brown, go ahead with your questions for Mr. Mullins, please.
Morning. Thanks for hanging in. Yeah. So can you give us your name? Tell us a little bit about your present job, your present responsibilities, just so the hearing examiner has.
My name is Tom Mullins. I am the Director of Capital Projects here at the Issaquah School District. I oversee any of the capital projects that happen here at the district, construction projects, remodels, those type of things.
Thank you. Did you work on the proposal for the Issaquah School District project on Providence Heights?
Yes, I did.
And what were your responsibilities, more or less?
I oversaw the team that went through the land use process, the consultants, the design team, and oversaw that process as it went through the city and all the other jurisdictions.
And in doing so, did you help with the present layout, the site plans for the school? I assume.
Yes, I did.
Okay. So you're familiar with them. Yeah.
It's somewhat, yeah. It's a large, complicated project.
Very, yeah. Level 5, and now we're down to level 2. Yeah, thanks. Did you participate in any discussions about the preservation of a perimeter buffer between the school development and Providence?
Yes, I did.
And would you say that there's quite a strong buffer there? It was.
We felt that the buffer was stronger or more robust than code required.
Thank you. Yes, I understand it. And it was uninterrupted around the entire perimeter. Correct?
Somewhat. I'm not sure exactly what uninterrupted would mean, but yes.
Thank you. Thank you very much. Okay. Let me move on now. Candy, would you mind pulling up exhibit 46?
Which one is that one?
It is, it is the license agreement. Mr. Bush submitted. License agreement is the title.
That came from Mr. Bush. Doug will share it for you. Thank you.
Who's doing the sharing, Candy?
Doug was able to pull up the exhibit.
Okay, all right.
You share it, Doug, when you're ready.
Okay.
Let me know when you see it. I have it pulled up now.
All right, thanks, Doug.
Mr. Mullins, I wanted to ask you, were you aware of this license agreement for an easement and lease drawn up on October 25th, 2021 between your colleague, Mr. Cooper, and the cell phone carriers? This would have been during a time you were involved.
Yes, I was aware.
You were aware. Okay. And if so, did you present it to the school board?
I did not. This wasn't something that I was intimately involved with. I was aware of it in passing and it had been mentioned. But I wasn't intimately involved in it, nor did I sign it.
Okay, but you were aware of it.
Yes.
Because this is important. Because it shows that plans were being made without full disclosure and so forth. If we take a look at the final drawing itself, and Candy, if you could move that, or Doug, to, I believe it's page 5, or
Is this I'm on page 5 now, Ms. Brown. Is this what you wanted to see?
really, I wanted to see the drawing. It's the drawing, I'm sorry, on page would be 11 appendix.
Is this the drawing you're referring to?
Yes, thank you very much. If you look at it carefully, this drawing is for an 85-foot tower in the upper section by the bus parking lot. And I realize this is complicated, but where that little square is. And the wording throughout the agreement, the entire 10-page agreement, makes it clear that this is only temporary, to be removed and the site restored afterward. A temporary 85-foot tower. Would you agree, Mr. Mullins, that that's what you understood this to be?
Not necessarily. I'm not sure exactly of this drawing or the notes. I can't see what it says there exactly.
Well, the drawing also is not an official plan. It's not to scale. It does not include any accoutrements or equipment. but it is an agreement, a license given by your school district. And it's for a temporary 85-foot tower.
Okay, I'll have to take your word on that. Like I said, I haven't read completely through the document or seen the exact language, and I'm having a little hard time seeing the drawing right now.
Yeah. So it sounds like it wasn't very widely discussed during the negotiations, or even the perimeter negotiations or the border. Could it have been perhaps kept a bit disclosed from other people working on this, negotiating, possibly the city, certainly the residents who were in on the negotiations?
I think there was always a cell tower location shown, not always, but the plans with the city, the plans on the project site, there was a cell tower location shown on the plans, if I remember correctly.
To be permitted by other parties.
Yes, to be permitted by other parties.
And yet we have a permit here of
Yep.
sorts. Yeah, that sounds pretty contradictory to me. There's something, sorry to use the word, it's not very legal, but fishy going on.
Hold on here. I just want you to
Yeah.
be clear your role right now, Ms. Brown. Your role is to ask questions of Mr. Mullins, not to issue your personal opinion on what sounds, contradictory or fishy or anything like that. You can certainly testify as a witness yourself if you wish, or you can save all of this for closing argument. I also have some trepidation here, Ms. Brown, just so you know, before we spend more time on this Exhibit 46. I am just really skeptical that any of this is relevant. You are not appealing a license between the cell phone company and the school district. You're appealing a permit that the city of Issaquah issued. I just don't see what difference it makes whether, why do I care what's in this license agreement at all?
I believe it's extraordinarily important because I will show you. I just have another quick question.
All right. Maybe we can tease out some relevance about this. Okay.
I believe it's very important. And we must remember that it was put in as an important exhibit by the applicant. So there must be some bearing here. It's not something that can be, yeah. So, okay. So let me just finish up here. Turning to just one other question. There's, let's talk for a minute about the city council decision and what's going forward. As was said, it is important to know what the present plans are and what is happening. And I understand, Mr. Mullins, that finances are a key issue now for the property, and much more funds are needed to process with this plan. How does the ISD intend to obtain the funds so that they can go ahead with their project, including, we're talking about this parcel?
Objection, relevancy.
Your Honor, may I object to that? Go ahead.
The
Sorry,
objection is
Ms.
sustained. Objections, both of the objections are sustained. We're not going to talk about the funding of the school district for its projects. That's not relevant to this appeal.
I believe then any discussion of removal of the water tower would also be irrelevant. Is that right?
I think so, yes. Unless removal of the water tower means that the ASDP has to be reversed, which I can't possibly see how that would be the case. Yes, I do think that's irrelevant.
So let's just go back. I will finish with Mr. Mullins with the question about this agreement. Exhibit 46. If I understand, this agreement, as I mentioned in my opening statement, has expired. So if it bears on a license or vehicular easement, which is needed as a condition for ASDP 22, it no longer bears any importance. Is that correct?
I'm not sure.
Objection, Your Honor. It's asking for a legal conclusion.
Objections overruled. One of the appellant's exhibits is this notion that an ASDP requires a vehicle easement. One of her issues that she's raised is that they don't have one. Perhaps this exhibit 46 may be evidence that they are lacking a required easement. I don't know. So I'll certainly allow this line of questioning.
Thank you.
Could you repeat the question?
Sure. Yeah. Actually, it's sort of two questions, but as I mentioned in my opening statement, the license appears to have expired. And this is for an easement, a vehicular easement, which is required for ASDP 22. I'm also concerned about the
Wait. Stop. Hold on. So this is called a compound question where you rope like 30 different questions into one. Break it apart in little chunks. Ask him if this agreement includes a vehicular access easement. Ask him that.
Okay. Does this agreement include a vehicular easement? I point you to, I believe, page 5.
And this is called leading the witness. Thanks, attorneys, for biting your tongues there. You know, we're not in court. Things would look very different for Ms. Brown if we were. Just trying to push this along here. All right, show us where it says vehicular easement, Mr. Mullins.
Yeah, I don't have the document in front of me. I don't know. And again, I'm not familiar with all of the parts of the document to know.
Right.
Yeah.
So Ms. Brown, I'm not going to let you keep questioning Mr. Mullins on a document that he does not have, has not read, and is not familiar with. I don't see the value of what he thinks might be in there.
That's fine. Yes, but I will conclude this. I am concerned that he didn't know about this at the time of negotiations going on, and that it has not been.
I've got to stop you right there. Got to stop you right there, Ms. Brown. Your role is to ask questions of Mr. Mullins, and I've just said you can't ask him about a document that he can't read. So, do you have any other questions for Mr. Mullins at this time?
Don't believe so.
All right, thank you. We will now open to cross-examination, beginning with the city. Ms. Soto, questions for Mr. Mullins?
I just have one question. Mr. Mullins, you testified that I believe the phrase you said was that the vegetated buffer was stronger and more robust than what was required by the code, or something to that effect. Do you know if the buffer or the vegetated buffer is in place right now?
As I understand it, the existing buffer that was there is in place, and it will be enhanced as part of the project, the larger project, I guess, as you call it, it's being referred to as the parent project.
And that would that be handled through the Native Growth Protection Area easement?
That I'm not sure of exactly. I know there are some gaps in the buffer now from existing conditions, and as part of the project, we were going to infill a lot of those areas.
No further questions.
Additional landscaping.
Thank you. No further questions.
Sorry, you're on mute. No questions from Mr. Bush.
Thanks. And I don't have any questions either. Thank you so much, Mr. Mullins. Ms. Brown, do you have any redirect based on that one question that we got from Ms. Soto?
I don't think so.
All right. Thank you. Mr. Mullins, I appreciate your testimony. You are excused.
Well,
you're not. Is the city planning to call him back later as a witness for their side?
No.
All right. Who's your next witness, Ms. Brown?
Minnie Dalloway.
Okay, let's get her on here. Not seeing anyone on my end. Not sure if this is technical problems or what. Ms. Brown, who are you calling as your witness?
The Community Planning and Development Department, she's the director.
That's who I thought, yeah. Is she here?
Dalloway.
I do not see her here right now. I just messaged her and seeing if she just jumped off or something.
All right. Was she here earlier?
I wasn't paying attention if she's.
I didn't see her, but I don't know. All right, Ms. Brown, we'll give a minute to see if we can find your witness for you. Ms. Brown, did you tell the director that you were planning to question her?
Yes, in fact, I sent an email yesterday.
Oh, all right. Well, she ought to be here then.
She said.
Well, let's do this, folks. So we've been going for just under 2 hours here. Let's take a short break here while we track down Ms. Dhaliwal, and we'll come back at 11 o'clock. So that'll give you 9 minutes to find her. If she's not here at 11, we'll call another witness just to keep this thing moving forward. Does that work? Oh, yes.
I just wanted to say this is Douglas Yormick, Associate Planner with the City of Issaquah. I have reached Minnie Dhaliwal. She does not have the meeting link, so I'm sending that to her now. So we can still continue with our break until 11, and she can join us at that time.
Perfect. Excellent. Well done, Doug. Thank you so much. All right,
You're
11
welcome.
o'clock, everyone. Okay, everybody, it's 11 o'clock, at least on my screen. Candy, can you give me the thumbs up to let me know that we are still recording the audio?
Yes, you can go ahead and return right now.
I didn't quite catch that.
Yes, you can go ahead and return now.
Okay. All right, and do we have Ms. Dhaliwal present either on the Zoom or on the room?
Hearing examiner, I am here.
Good morning, Ms. Dhaliwal. So our appellant, Roberta Brown, was just about to ask you questions, but first I will swear you in as a witness. Will you raise your right hand, please, ma'am? Do you swear or affirm the testimony you give today will be the truth?
I do.
Thank you, Ms. Dhaliwal. And although I have your name on the screen, it is the audio that is the official record. So would you mind spelling your name for the audio, please?
Sure. My name is spelled Minnie, M-I-N-N-I-E. Is my first name. Last name is spelled D-H-A-L-I-W-A-L.
Thank you so much, ma'am. And what is your role with the city?
I am the Community Planning and Development Director.
All right. Ms. Brown, go ahead with your questions for Ms. Dhaliwal, please.
Thank you, Minnie, for coming. I appreciate this. I appreciate all the work you're doing too. I'm so fan of what you've done. Do you want to just tell us very quickly, for the hearing examiner's knowledge, 2 sentences, what your main responsibilities are as director?
So I'm the Director of Community Planning and Development. I'm also the SEPA responsible official for the department. So I oversee a staff of 30 staff, full-time employees that are responsible for the planning, engineering, and building divisions, including code enforcement.
Thanks. So I'm going to try to go rather rapidly for the sake of falling behind here. I would just ask, what were your roles in the permitting process for the ISD school project, the master site plan? So I know you were present then.
Sure. Are you talking about the approval from the Development Commission? So my staff and I was responsible for making a recommendation to the Development Commission. The decision after the public hearing was made by the Development Commission for the Issaquah School District Site Development Permit.
Great, yeah, thank you. So you were quite involved, I remember. Yeah. So in the staff report for the school project, the only mention of a communications utility in the entire 175-page school project staff report is a 2-sentence statement allowing for a cell tower on wheels.
Objection, Your Honor. It's speculation. She's not pointing to a specific document. She's making her opinion.
And
So wait, let me stop you there, Ms. Brown. I'll sustain the objection. Your role here is to ask questions of Ms. Dhaliwal, not to offer your own opinion. If you want to ask her a specific question about something in the staff report, can you give us an exhibit number of the staff report, please?
Absolutely. I appreciate the correction.
Oh, comes with the territory.
This is something new to me. So,
Oh, I know.
yes.
No, it's yeah. With this, as I say, this is much less formal than court, but it's not just totally loosey-goosey.
Yeah. Sorry, Minnie. Could you bring up exhibit PRJ 19? That is exhibit 15
Thank you.
and page 175.
All right, I see it on my screen.
See, doesn't look quite right.
Page 175 is conditions 42 through 48.
Oh, this is, you have exhibit 15, not the city council.
This is the 15 PRJ 19-0008 final staff report, 2022-2014.
And I do apologize, it's page 159. That's an excellent.
All right, so we're now on page 159 of exhibit 15.
So, yeah, and again, process-wise, I will try to do this well. So many, there is the statement there about a temporary, a cell tower on wheels, which is temporary. Can you tell me about that? Perhaps why it was put there and what your understanding is? That a fair question?
I'm trying to read the sentence. Can this be zoomed out by any chance? It's hard for me to read.
Doug, can you blow up paragraph?
Okay, there you go. Thank you. That's helpful.
Oh, great, awesome, okay.
Yeah, I think this was put in the interest of being extremely transparent with everyone as to what would happen to that existing tower. It by no means is saying this approval is approving anything related to a temporary cell on wheels. It's just saying that that's a possibility that may, to maintain the coverage for the community, that would be an interim solution until the permanent relocation is put in place. So, but again, I think the last sentence is saying it'll be installed by others and a separate process applications. If I understood your question correctly, you're asking why was this put in? It was just to be, it's a finding for the criteria under it. It has no bearing on the ISD project, but I think it was just more as an FYI of the future project.
Okay, And it appears to be placed on the site, so perhaps the same site as the cell tower, until there's no site mentioned here, particular site, no mention of where it would go. It could be that on wheels, it could go anywhere, including right where the cell tower is.
Sure. Yeah, it would be processed under a separate applications for the location of new or temporary or permanent. So I think at that point, this project was not fully, at that point, it could be a temporary, it could be a permanent, but it'll be a separate process to approve either of those options, which is what happened with this current application that is part of the appeal.
Is there anything else that you recall in the staff report referring to temporary cell tower or anything?
I do not recall, but I think the site plans and stuff have shown a little box as a potential future with notes to say that'll be done by others under a separate application.
Yes. Okay. It was never, the cell tower was never discussed during the negotiations for the school permit, if I recall. Is that correct?
Negotiations between who?
Any talk of cell tower during the right up to the city council decision, there was no talk about a cell tower or where it would go. This appeared and there were some little white squares, but for a separate permit, but nothing else, right?
Yeah, the idea was that that would be approved under a separate process. That's correct.
Right. Yeah. And that separate process, if I understand, was labeled a proposed cell tower location, permitted and construction by others. So what I'm trying to figure out, and for the sake of our hearing exam, it sounds like there's nothing here that would permit a future cell tower location. This is all quite hypothetical. Would you agree with me on that?
I'm not sure I say hypothetical. It was not decided, and it's a separate process that would be followed for a relocation of the existing facilities. I think it's a fact that there were existing facilities on a water tank at the property, that water tank was going to get demolished as part of that proposal, and then a future location of the tower, whether it's temporary or permanent, would be handled under a separate process. That is correct.
Thank you very much. Yeah. And so now we've just discussed that there was, at the time that this permit and master site plan was being permitted, there was an ongoing license agreement between the school and Verizon for a temporary 85-foot tower. Were you aware of this?
I personally am not aware between, conversations between the school district and Verizon. That would be a question for those two entities.
However, okay, wouldn't there have been some reference to this agreement in the staff report if you had known of it?
I did not know about it, and then generally if it's not tied to the criteria of the approval in front of the Development Commission, we would not include it.
Even though the little white square on the site plan says a proposed cell tower location, and at the same time they had given a license for this location, be it temporary and only 85 feet.
Objection. Ms. Dollywall has already addressed that she is not familiar with the license agreement. This does not seem to be relevant and should be something addressed by other witnesses.
I'll overrule the objection. I don't know where this is going. I assume it's going somewhere useful, so I'll allow Ms. Brown to keep asking.
Thank you. So it does sound like, and again, we look at this paragraph, there is a temporary cell on wheels. And that's what, in all honesty and transparency, the city tried to present to leave open whatever would eventually happen. And we all understood at the time that if a cell tower goes in, a new one, it would be after all the development of the.
All right, so this is going too far. Brad, you can't be talking about what we thought. I mean, first of all, many problems, Ms. And now I'm going to give you a little lecture on this. So, you know, A, it's not a question for Ms. Dollywall. B, you don't speak for the community. If you want, if you want some kind of evidence about what the public thought, you can bring up someone who was at a public meeting and they can testify, oh, I was confused about what was proposed. But kind of a bigger point here, Ms. Brown.
Thank you for the correction.
No, the question's not open.
I just have one last question.
Ms. Brown, I am talking at this time. A bigger problem for you, Ms. Brown, is that I don't see how any of this stuff about the license between the cell company and the school district, or the amount of notice that the public was given on the master site plan that there would be a permanent tower, I don't see how any of that remotely helps your appeal.
Thank you. Okay,
So,
no, that's fine. No, I appreciate your help. I am just concerned about the non-disclosure of an important document.
I understand that you are concerned about the non-disclosure of an important document, ma'am. That is not your appeal. And if this was like a Public Records Act case in Superior Court or something, maybe things would be different, but that's just not the case that you have, ma'am. So I will ask you to move on to the case that you have.
And all I would say, thank you, I will do that. This was just brought up recently. Had it been in the court documents, I believe it would have been shown, but it was hidden. So I do believe I can bring it up, but I will certainly honor your decision on that. So that is my final question. It appears that I appreciate your help, Minnie, and talking about this, and the knowledge that you did not know of this ongoing agreement between the property.
All right, no,
Objection.
Ms. Roberts, no, you're doing it again. Your time now is to ask questions of Ms. Roberts, not to highlight particular aspects of her testimony that you thought were valuable. You will have an opportunity to do that during closing argument, but not right now, Ms. Brown. I've
Apologize. Yes.
doing my best to have a hearing that is both efficient and fair, and what you're doing now is neither. So I said you were done with Ms. Dollywall, so let's turn over now to cross-examination by the city. Ms. Soto, do you have any questions for Ms. Dollywall? Also, we can take down the screen share, please, Doug.
I have no questions at this time. Thank you.
Thank you. Soto, Mr. Bush, questions from the applicant for Ms. Dollywall?
No questions, Your Honor. Thank you.
Thank you. And I do not have any questions for you either, Ms. Dollywall. Thank you so much for your testimony. And unless someone else is planning to call you, I think you can go on about your day.
Thank you. Thank you, everyone. Bye.
All right. Next witness, Ms. Brown.
Doug Yormick.
I'm sorry, I didn't hear the name.
Mr. Yormick.
Okay. All right, Mr. Yormick, you'll have to take a break from running our projector and come testify as a witness. Let's get you sworn in. Will you raise your right hand, please, sir? Do you swear or affirm the testimony you give today will be the truth?
I do.
Thank you. And can you spell your full name for the audio record, please?
Yes, it's DOUGLASYORMICK.
And Mr. Yormick, what do you do when you are not helpfully projecting exhibits for us during our testimony?
I am the Associate Environmental Planner with Community Planning Development, City of Issaquah.
Okay. Ms. Brown, go ahead with your questions for Mr. Yormick, please.
I got it. So how would you, I'll just the general question here. How would you describe your responsibilities? I think you have maybe already done that.
Yeah, in this particular case, I reviewed the application in front of me for compliance with Issaquah Municipal Code.
And you are the one who processed and signed off on ASDP 22, is that right?
That's correct.
Thanks, as well as the earlier permits. You're sort of
Mhm.
overseeing this project. Yeah.
Yeah.
Yeah. So I have a question. When I first met you about the height variance application, I mentioned some areas of non-compliance with the school project. And you replied that you weren't involved in the school project. So you weren't aware of that. Is that correct?
Yeah, I was not a part of the Issaquah School District project.
Thank you. Yeah. Could you bring up Exhibit 46 again, please, Ken?
46,
Yeah.
did you say?
Yes.
Okay.
Give me one moment.
Thought I have it this time, Doug.
Okay. At least on my end, we are now looking at Exhibit 46.
Can everyone see the screen?
Yes, sir.
Okay.
Actually, can we go to the end to page 11?
The
Page
site
11.
plan?
The site plan, yeah. So Doug, I don't know if you've seen this before. This is an agreement that was going on between the school and Verizon for the location we're talking about. And were you aware of this, or have you seen it before it was submitted 11 days ago?
No, I was not aware of this agreement between Verizon and Issaquah School District.
Thank you. So it was not disclosed to the city or to the.
No.
Okay, thank you very much. If you look at this, there is a clear difference between what here is a temporary 85-foot high tower and a permanent 150-foot tower in the middle.
Objection. Again, this is Ms. Brown's opinion. We've gone over this several times now.
No, I'll overrule this objection. If she wants to ask, like, is there a difference between a temporary 85-foot tower and a permanent 150-foot tower? I mean, I think that's a reasonable question. Well, I hope that was going to be your question, Ms. Brown. I hope the question you were planning to ask was a reasonable one. I'm giving you the benefit of the doubt here.
You stated better than me. Thank you. So Doug, yeah, that was the question.
Is there a difference between an 85-foot temporary and a 150-foot permanent? Yes, one would be temporary until a permanent location has been constructed. There's a separate or a different permit process. I believe in 1822 it would be just a building permit. There would be no land use permit required for a temporary cell on wheels. So those would be the differences between a permanent and a temporary.
Thank you. And so this was ongoing as an in-force agreement, I believe, when some of this project began. Thank you. Yeah, I'm concerned about the difference between those. So given that this was not my last question for you, Doug, given that this document was not available until 11 days ago, do you believe really that the application or the permit was complete?
Yes, in my staff report, I highlighted how the proposed new macro site, which would be at this location, met the criteria in 1822.
Can you tell us, Mr. York, when you say your staff report, which exhibit number are you talking about?
Oh, off the top of my head, I don't know.
But the reason I ask is we've already had the staff report for the master site plan, which was, I think, exhibit 15.
Yeah, I think this is exhibit 1.
Yeah, we're now talking about your staff report on the ASDP permit, right?
Correct.
Yeah. All right, and you thought that was probably Exhibit 1 that we're now talking about. Notice of decision is Exhibit 1, but it's a really good notice of decision. It's got, rationale and so forth. So is that the document we are discussing?
Yeah, that's what I'm bringing up.
5 pages long?
Mhm.
Yeah, okay, all right. Very good. Continue, Ms. Brown.
Thank you. Yeah, and there's no mention of this 85-foot temporary tower in your staff lead.
No, because the permit application was for the permanent location. If the applicant wanted to go through and install a temporary, they would have to go through the building permit process.
Thank you.
It would still be reviewed by the city, just a different permit.
Just have one last question for you. There was talk, I believe, by the attorney for the city about that the master site plan could be reconfigured. I forgot the word, the exact, to meet the needs for this. Have you received any information about that or anything about trying to reconfigure the master site plan? And again, I use the incorrect words. The master site plan so that this could happen, including use of the loop road.
No, we have not received anything for an amendment to the master site plan, or forget. Now I'm blanking on the term too. I think I have it up here.
I think amendment was the correct term.
Yeah.
Amendment, thank you. Yeah, I think that's it. So there's been no attempt to amend the master site plan to allow for a permanent thing, to your knowledge.
No.
Thanks, Doug. Appreciate it. That's all.
All right, questions for Mr. Yormick by Ms. Soto.
I have no questions at this time on cross-examination, but I may call Mr. Yormick as a witness for the city's case.
Makes sense. Mr. Bush?
Yep, the same, Your Honor. Thank you.
Okay, I guess I have a question for Mr. Yormick. At what point in the master site plan process did this notion that there was going to be a temporary cell phone tower become a notion that there was going to be a permanent cell phone tower?
I'm not sure. I was not aware of during the master site plan that it was going to be a temporary cell on wheels. It's my understanding that from the very beginning, there was going to be a permanent replacement to the current infrastructure that's on the water tower on site.
All right, thank you, Mr.
Yeah.
Okay, Ms. Brown, did you have any follow-up question to the one question that Mr. Yormick just received?
No, that was my understanding of what your understanding was.
All right, thanks. Okay, then I think we can move on to your next witness, Ms. Brown.
Yes. My next witness is Leo Graham.
All right. Is Leo Graham there in the room with you?
This room, where would you like me to sit?
Well, I guess, I don't know. Do whatever Candy says. That's what I do.
Wherever you want.
This works for me. Good morning.
Good morning, sir. Let's swear you in. Will you raise your right hand, please? Do you swear or affirm the testimony you give will be the truth?
Yes.
And can you please state and spell your full name for the audio record?
Leo, L-E-O, Graham, G-R-A-H-A-M.
All right, Mr. Graham, and what is your role in all this?
Well, I am a member of the Government Affairs Committee for the umbrella board of the Providence Point Homeowners Association.
Okay.
Homeowners Association, actually.
All right. Ms.
I've
Brown?
been on the committee for some-
Wait, that's good enough for me. I just needed to know who you are. All right, Ms. Brown, go ahead with your questions for Mr. Graham, please.
So, Mr. Graham,
Ms. Brown.
Ms. Yes. You involved with any of the early discussions with Mr. Mullins, with others during the design phase of their school development?
Yes,
And your goal, if I understand, was sort of to maintain a substantial buffer between the proposed development and the Providence Point community.
yes. I can,
Can you tell us a little bit about that so that we know what this buffer was to be like?
yes. At the invitation of the mayor and the planning director several years ago, I, as a member of the government affairs committee and the then president of the umbrella board, several other residents at times met with the mayor, the development planning director, the Issaquah School District superintendent, CFO, their planners, city attorney was there at one point, and others, different meetings, to discuss the interplay between the proposed schools and Providence Point. The point being, and as the mayor raised it, the development would have a significant impact on Providence Point and the residents in Providence Point. They wanted to make sure that there was some process under which we would discuss the development of the site and see if we could come to some conclusion as to what would be appropriate to mitigate some of the impacts for the homeowners. The buffer was a key component of that discussion. Security was a component, fencing and the like. The football stadium, the noise pollution, the sound, size, all of the situation that would have been created as a result of that football stadium. And then the placement of the school buildings and any of the other facilities on the site. The buffer was proposed by the school and city staff. Initially, planning department had even suggested that the 6 acres running along our contiguous border be rezoned to not allow any construction of any type within that area. That was amended by the city council during the planning process. So they were attempting to create some sizable buffer. It ranged in size over the discussions to mitigate the development of the site. I participated in those discussions, ultimately resulting in the hearings before the development committee and the city council. Our understanding from the Providence Point standpoint, as a part of the umbrella board, Providence Point is a condominium owners association. It has a governing board for all the common areas, and all the buildings are part of that process, part of that association. It was our understanding that we were going to maintain and where the development of the school and any facilities that were on that property, so as to mitigate the size and scope of this development on 40 acres. And that's what we believed was the result in the master site plan. If we were aware that it was going to be a 150-foot cell tower, a plastic tree, sitting 35 feet away from our border, 30 feet, and directly adjacent to our residences, that definitely would have been a major point of discussion and objection by Providence Point.
A few other questions? The area that we are now discussing, that I have appealed, was that a particularly sensitive area, do you recall, during the discussions?
It was identified, numerous experts were retained by everyone, including Providence Point, environmental experts, arborists, and so on. They identified that area as being highly sensitive because of the historic drainage in the area meant there were wetlands and other features in that area that could be significantly disturbed by this development. And there were, again, attempts to mitigate those disturbances and environmental impacts. The goal being, again, to maintain a contiguous, non-disturbed buffer enhanced where necessary as a result of the building of retaining walls and other structures for the benefit of both sites, but in particular to mitigate the impact to Providence Point.
And if I recall, can you tell us, there was discussion too about keeping the vegetative buffer because that's where the school buses are planned to be.
In this area where the proposed cell tower, which wasn't a topic of discussion during any of this process leading up to the decision because it hadn't been, well, we weren't aware of it. I don't think the city, well, apparently the city wasn't, but in any event, yes, because there's going to be at least 30 buses sitting there in the morning immediately adjacent to residential housing that are going to be in use day in, day out, coming and going, starting early in the morning. And we wanted to maintain as much sound buffering in that area as possible. And that was a point of discussion. And believed that the site plan did that and would control that and mitigate that issue for those residents.
Thanks. One last question. So these negotiations were going on. If I understand, now it would have been at the same time that the license agreement that we just brought up, Exhibit 46, between the district's CFO and Verizon was drawn up inside, or a temporary tower. But even that, was that brought into the discussion at all?
No, it was not brought into the discussion. The discussion was that the cell tower at some point would be removed. At that point, the city ordinance was an 85-foot limitation on height and other limitations. We assumed that cell tower would continue to be in the vicinity of the water tower. Nothing was said to the contrary. If it had been disclosed that the intent was to put it on our property line, essentially, 150-foot plastic structure looking something like a tree as a cell tower, it would have been a significant topic to be discussed leading up to the hearings.
So it was not disclosed, you're saying, either
It was
to,
not disclosed.
and it looks like it was not disclosed to the city. Thanks very much.
No opinions by you there, Ms. Brown. You're here to ask questions, not to testify yourself. But I think that's your last question for Mr. Graham, was it not?
I think that's, yeah, thank you. Anything you'd like to add?
No.
Okay, all right, then let's hear some cross-examination by Ms. Soto if she wishes.
I have no questions for this witness. Thank you.
Thank you. Mr. Bush?
Hi, thank you. Hi, Mr. Graham. Could Mr. Yormick bring up Exhibit 15, page 20, which is a drawing site map for the proposed project?
Yes. Give me one moment.
Thank you.
I'll just note
Thank you,
Exhibit 15 is the staff report for the master site plan decision. And you said which page, Mr. Bush, from that? 20?
I'm sorry, 20, yeah.
All right, page 20, got it.
Just two areas of question for you, Mr. Graham. First, you mentioned an assumption that the proposed tower would stay in the vicinity of the existing water tank site. Calling your attention to page 20 of the staff report. Do you see the location for the wireless communications facility that is shown on the drawings?
If you're talking about the little square, does that say somewhere on here wireless communication? I can't see it.
Sure, it is hard to read. I appreciate that.
Well, it's very hard to read, Mr. Bush, because it's not there, is it? Is it on this page, Mr. Bush?
No, the square is on the page. I was asking you about the square that's on this particular page.
Yeah, the square is there. It doesn't say cell tower, right?
That is correct.
All right.
And the small type adjacent to the square refers to the access route, not the tower itself.
No, it doesn't. Wait, no, it says wetland exempt. I've got it on a bigger screen. Yeah, I've got the.
Yeah, I'm squinting at it. Yeah, it doesn't. Yeah.
All right, where are you going with this witness, Mr. Bush?
Well, I just want two things. One, I want to confirm that the location of the wireless communications facility is on the site plan. And I can scroll to other additional pages further down in the staff report to identify the wireless communications facility at that location.
Why don't you do that?
Is there a question in there?
Well, hold on. Mr. Bush said that he could find other pages to ask you about here in the staff report, and I was encouraging him to do that. It is his question. He can always just, stop. But if he's got some page he wants to ask you about, I'd be interested to hear your testimony.
I had it written down and it's buried in the minutes.
Maybe page 52.
I had a different one, but let's go to 52, Mr. Yormick. I want to zoom in on that, the mice type in the lower right.
Yeah, boy, if you thought the lettering was small on the first one, where do you see this one? But I can just make it out.
And I have it open on my screen here as well, separately from
it's a little bit clearer on my screen, and I see the magic words proposed cell tower.
Okay. Did you see this portion of the staff report during the the master site development plan process? We're called out the cell site on this particular page.
I can tell you, I don't recall seeing it. I can't say that I didn't at some point, although I have to say, getting all of the documents during that process, with all of the different expert reports and so on, I'm not sure we got all the documents as the residents in any event.
And I appreciate it's a large record. I appreciate that.
It was not pointed out to us by anyone from staff or the school. And as I think it's Mr. Mullins, who we also talked to during these process, indicated it was a moving target, apparently.
Okay. Well, let me be just fair and direct. Were you personally aware that this was the proposed location for the wireless communications facility at any time during the school district project?
No. Was I personally aware of this particular map? I've seen.
No, were you personally aware that this was the proposed location for a wireless communications facility at any time during the school district project planning process?
Again, because there was so much documents, not that I recall. It's the best I can.
And that's a fair answer. That's a fair answer. And then concerning the current appeal and the applications that led to the current appeal, did you receive notice of the application for the actual wireless communications facility at this location?
No.
Did the association receive notice of application for this wireless communications facility?
I don't think so. I can tell you it didn't come to the government affairs committee that I recall. It came, the variance request did, certainly.
Okay.
We learned they were asking to put up 150-foot plastic cell tower, tree, whatever it is. That's, yes, that we knew about.
Okay. Okay, and then did you participate in that variance hearing process?
I don't think I was at the hearing.
Okay. Did you provide comments? You were aware of the variance. There we go. You were aware of the variance application process.
I was aware of it. Yes.
Okay. And then this is a separate application for the site development permit. Did you participate at all in providing comments for the site development permit, either personally or on behalf of the association?
You mean the master site development?
For the wireless communications facility, the SDP that's under appeal.
I participated in the letters that were written to planning staff with regards to opposing that request for a variance.
Okay, very good. Thank you. No further questions.
Thank you, Mr. Bush. And I don't have any questions for you, Mr. Graham. Ms. Roberts, do you have a follow-up question for Mr. Bush? Sorry, for Mr. Graham, based on the questioning by Mr. Bush?
I thought Mr. Bush.
Yes.
Not as good.
Okay.
Okay,
I think we're good.
Let's move on to the next witness then, Ms. Brown, and Mr. Yormick, you can please take down the exhibit 15 there. All right, Ms. Brown, who have you got for us?
The next witness is to speak about the present school plans in terms of finances and what they will do, whether this tower is necessary. I will to you, that's fine. I understand. Thank you. So I am done. Thank you.
Oh, those were all of your witnesses that you're planning to call?
That's it.
All right. So the next order of operations here, as I said in my opening remarks this morning, is we will now hear from the city. The city will present witnesses one by one. They will be subject to cross-examination by Ms. Brown. I don't think they'll be subject to cross-examination by the applicant. And after we get done the city witnesses, then we'll hear the applicant witnesses. After that, Ms. Brown can call rebuttal witnesses, if any. Ms. Soto, it's 11:45. In my fantasy world, we get done with the entire hearing today. How many witnesses is the city planning to call today?
The city may call 2 witnesses, but I was actually going to suggest if we could break for lunch,
Sure.
And then come back in the afternoon and hopefully finish up today. I'm optimistic as well that we should be able to finish today.
Well, Mr. Bush may have something to say about that. Mr. Bush, how many witnesses are you estimating?
I am planning 1 witness at this point, Your Honor.
All right, so it sounds like probably about 3 more witnesses, and thanks to everyone's efficiency, we got done with 4 witnesses in about 1 hour and 45 minutes, which is a terrific clip. So I really appreciate the effort that folks have made to kind of push this along. So yes, I think we can take a reasonable lunch break and still attempt to get done at a reasonable hour. Maybe I should check in with Candy. Candy, how late can we go today before they kick us out of the room, or before the...
5. I have room till 5.
5 o'clock, we got to be done. Okay, all right. Well, let's say 45 minutes for lunch, everybody. Can we be back at 12:30? Does that work for everyone? I see heads
That
nodding.
works.
Excellent. 12:30, and we'll begin with the city. We are
Thank you.
Thank you.
All right, folks, it's 12:30. I'm going to call us back to order here. Can I make sure that we have our city attorney and our applicant representative, please? Can you guys turn on your cameras so I can make sure you're right? There's Ms. Soto. Hello. And there is Mr. Bush. Okay. Candy, have we resumed the audio recording? Okay.
Yes.
All right. So where we left off, we were just about to begin with the city's witness. So why don't you go ahead, please, Ms. Soto?
I'd like to call Christian Geitz, but I'm not seeing him in the room. Let me me message him real quickly. And if not, then I'll move on to our next witness.
All right. Is he a city employee, Mr. Gates?
He was as of last Friday, but he's recently taken a new position. So he's been so kind to still attend the hearing today.
All right.
If we can give him just a minute, and again, if he doesn't come within the next like minute or so, then I'll move on and call him next.
Okay.
I'm not seeing him, and I'm not getting a response from him. So perhaps we'll just move to the next witness and call him second.
Sounds good.
All right. Next, the city is going to call Doug Yormick.
All right, Mr. Yormick, let's see you on video, please. There you are. You remain under oath from this morning, sir. And I think we already know your position with the city. So go ahead with your questions, please, Ms. Soto.
All right, Mr. Yormick, we talked earlier today about access to the site. Did you review access as part of your review of the ASDP that's on appeal today?
I did. I'd asked the applicant to provide easement information for accessing the site. I was provided an easement, and it was also shown on, I believe it's Exhibit 2 of the core documents on the site plan.
Candy, can we please pull up core document 1, Exhibit 2? It should be a site plan.
My core documents 2 is called code compliance. Oh, I see. This is Exhibit 2 to Exhibit 1.
Yes, it's a little confusing,
Yeah.
but it is listed as Exhibit 2.
Exhibit 2 or Exhibit 1? I'm sorry, you guys are talking over each other.
It's called Exhibit 2 Plan Set.
The core documents?
Yes.
My core documents too, says code compliance as well.
Yeah, if you go,
I can share my screen.
X2, so like there's like 1-codecompliance.pdf. If you go down to ex2-planset.pdf, that's the one she's talking about. The Bates number is 0008. Technically, it's part of Exhibit 1. That's why we're being weird about the names.
I have it up on my screen. I can go ahead and share mine if that's okay with the hearing examiner.
Let's do, please.
Okay.
Fast enough.
Okay. Can you see that?
I can.
Okay. So this is, can you explain what this document is?
Well, hold on. Let's see. What page are you on? Are you on page 3?
Sorry. Okay. So can you please explain what document this is? This is page 1 of this document.
Okay.
Yeah, so this page, well, this is the first page. This is the cover sheet for the plan set for the administrative site development permit.
Okay. I'm going to go to page 3. Can you see this okay?
I can.
Okay, I'm going to blow it
to
up.
my larger screen, so you're going to get a side view of me.
Okay, I'm going to blow it up just a little bit. So can you explain what this is depicting that I'm showing with my cursor here?
So that is the property, one of 3 for the Issaquah School District elementary school and high school project. The wireless facility, the current wireless facility on the water tower is located on here, and the replacement of that wireless facility is also located on this property.
Where is the current one?
It's on the water tower, the water tank.
Where is the water tank?
I'll use my cursor to point. Is this the area right here?
Yes, that's the water tank.
Yep, I see it.
Okay. And then this area right here with the square, is this the proposed area for the ASDP?
That's correct.
Okay. And then you mentioned that you had reviewed an easement that provided for access.
Mm-hmm.
Can you provide a little bit more explanation about that in light of this exhibit?
Yeah, so the applicant provided me with an easement from 1997 for wireless communication facility for ingress, egress on this property to the water tower site. It's depicted as note 18 on the site plan that you were looking at.
So these triangular numbers 18, is that the easement that you're referring to?
Yes.
And then it's noted again up here under easements, this 18, is that what you were referring to?
Yeah.
This telecommunications easement? Okay, I'm going to stop sharing my screen for a moment.
You do.
Oh, sorry.
That's all right.
I was too fast.
So imagine I wanted to drive the length of this easement. Walk me through the entire route because I see some dashed lines. Is basically all the dashed lines the easement?
Yes, so all of the dashed lines are the easement.
So the easement's got two, let's say outlets, one to the southwest and one to the east. Is that correct?
Yeah.
Okay, gotcha. Thank you.
Okay. And so as part of your review of the ASDP, you then did you review that wireless easement recording number 97080700197?
Yeah.
And I'm going to pull up Exhibit 43. This is Exhibit 43. Are you familiar with this document?
I don't see it.
Oh, I'm sorry. Okay, I was too quick. Here we go. Exhibit 43. Are you familiar with this document, Mr. Yormick?
Yeah.
And can you explain what this document is?
This is the easement agreement between the former owner of that property, Lutheran Bible, and wireless carriers.
Okay, and then scrolling through on page 2 of Exhibit 43, can you read paragraph 1?
Yes, I'm going to put it on my larger screen. Just a second. Grantor hereby conveys and grants to the grantee, its successors, agents, and assigns and guarantee accepts from grantor a non-exclusive appurtenant easement over, under, across, and upon that certain portion of the grantor tract, or particularly described in Exhibit C easement tract, for the purpose of pedestrian vehicular ingress and egress to and from the leasehold property, and for the installation, operation, and maintenance of utilities serving the leasehold property.
Thank you. And can you also read this language in paragraph 2? I'm going to highlight it. The language for you to read appears to be the second sentence.
Grantee covenants to utilize the easement tract only for the purpose of ingress and egress and the installation, operation, and maintenance of utilities necessary to construct, operate, and maintain a telecommunications facility upon the leasehold property in the usual course of business.
Thank you. So when you reviewed the application materials for this ASDP and reviewed these documents, did you determine that they had met condition number 1 of the variance that required proof of access?
Yeah.
Well, wait, how did you conclude that? Because as I saw the map of, easement 18, it led to the water tower site. It didn't lead to the square that's the new site, did it?
No, it did not. It loops around that site.
So how did you conclude that there was access to the square site instead of the water tower?
They have access to the property and they can, excuse me, then negotiate with Issaquah School District on the actual lease portion, but they still had access to the site.
Well, all right, let's take a look at the variance decision. What exhibit is that?
I believe that's Exhibit 7 to Core Document 1.
All right. Yeah, so here's the approval, and then we were just referencing condition number 1 of this. Let's see. Prior to issuance of the ASDP, the applicant shall provide their access easement to use Providence Loop to access to the lease area or revise the access location to a different location. So access to the lease area presumably means the square, right?
Mhm.
Well, the easement 18 doesn't lead to the square.
No, it does not lead directly to the square. It leads to a point that they could get access from ISD to when they have the actual lease area.
I don't understand what you just said.
So that square represents where the new tower is going. The providers will have to negotiate that lease area if they haven't already done that. The access will be to there. That the road goes, it's adjacent to that square.
Yeah, but it doesn't go there now, does it?
No, it's adjacent to.
Well, but so shouldn't this have been worked out prior to issuance of ASDP 22-0007? I mean, that's what condition 1 says, prior to issuance of our permit, not after.
Yeah, I see what you're saying with that.
Well, that's my question is, shouldn't this have been provided first? Yes or no?
Yes.
All right. Go on with your questions, Ms. Soto.
All right, thank you. Are you familiar with the temporary license agreement between the Issaquah School District and the wireless carriers that has been brought up already as exhibit number 46?
I was not aware of that until recently.
But have you since reviewed it?
Yes.
And when you reviewed that license agreement, did you determine that there was access to the leasehold site through using that license agreement?
Yes.
I have no further questions for this witness.
All right, so let's take a look at the license agreement. So exhibit 46 now is the new access plan. So I've got this called up. Ms. Soto, would you mind sharing exhibit 46?
Sure. Just one moment. Can you see that?
Yeah, can you go down to the site plan of it, page 15 of 15 here on exhibit 46? All right, and can you—
Would you like me to rotate this?
Rotate right so that the text is right side up. This thing is hard enough to read as it is. All right, so Mr. Yormick, you said that this is the document that now gives them access to the proposed site facility, right? The cell site?
Yeah.
All right. Why don't you walk me through how that access is to be provided?
That access comes from the north, traverses the site south to the proposed cell tower location.
So I see the school bus parking turnaround. I see, a road, let's call it a driveway to the left of it, unlabeled. And then there is a, in parentheses, N, ingress and egress connecting to the driveway. Am I correctly describing these elements?
Yeah.
All right. So that driveway is, I think, familiar to me from some of the other site plans I've seen from the MSP, right? That driveway's always been there?
Yeah.
Maybe I'll take a look at exhibit 36 to verify for myself that the driveway has always been there. One moment. Exhibit 36 is like not the best site plan. What's a good site plan to use for the MSP? What was the final approved site plan? What exhibit is that, Mr. Yormick?
For the MSP, I'm not sure which exhibit that is. I'm going through my list right now.
Anybody know what was the final approved site plan for the MSP?
Could be 36.
37, you say? All right, let's take a look.
I don't think it's 37.
I don't think so either. This is some like PowerPoint presentation. What's the final approved site plan? I feel like we were just looking at a bunch of site plans. We could maybe use the one from the staff report, which is Exhibit 15. Is that the best we've got?
Yes.
I know I saw a better site plan than this because I remember like getting agitated about it because I saw some inconsistencies when I was getting ready for this case.
There are site plans within the staff report.
Yeah, but they're like hard to read.
Yeah.
I think maybe these purport to be a planting plan, not a site plan. Let's see here. I wish I could have written better notes on this. Let's see.
There are landscape plans in the exhibits at Exhibit 36.
Or 36, right. My concern is that like there is a difference between a landscaping plan and a site plan.
Yes, right.
But for purposes of right now, let's go to Exhibit 36, page 15. No need to call it up on the screen. I take that back. Let's call it up on the screen. Can we do Exhibit 36 PDF 15? And I'll just note that the caption on this is overall materials plan. So who knows whether that's a site plan or not, but it's gonna at least get us closer than we are today. All right, zoom in on the square, would you?
Sorry.
No, I know it's horrible doing this. Make it even a bit bigger. All right, so that's maybe good enough. All right, so I see a cell phone tower here on the overall materials plan. I see the bus parking area that we were just discussing, and I do see a driveway connecting from bus parking to, what was the name of that street that's right there?
Providence Loop.
Was it Providence? What were we just looking at a minute ago? Yeah, Providence Heights Loop. From at least that's how it's described in Exhibit 46. All right, so and I think I even see, Ms. Soto, if you can make it bigger still, I even think I see a little connector between the cell phone tower square and what I'm assuming is the driveway for the school buses. And that connector sure looks an awful lot like what is labeled on Exhibit 46 as ingress egress. Is that right?
Yeah.
All right, so this is the new plan. Now Exhibit 46, it looks like it's been signed by various peoples. It's been signed by AT&T. It's been signed by the school district. I know we had some testimony or argument from Ms. Brown that it's maybe no longer valid. And I also note that Exhibit 46 is not a easement. It is a license agreement. Obviously, licenses are revocable and easements are not. So maybe we'll just go back to the language of the variance there. What was that one?
I have it. I can pull that up right here.
Yeah, well, what was the exhibit number for the variance again? It
It's
was
Exhibit 7 of Core Document 1.
Yeah, that's
Here.
right.
Here is that language on page 25 of.
Yeah, all right. So prior to issuance of ASCP 22-0007, the applicant shall provide their access easement to use Providence Loop as access to the lease area or revise the access location to a different location. So they either have to do an access easement or else revise the access location to a different location. That's not very well worded, but I think it does give them at least a little bit of flexibility, doesn't it, Mr. Yormick?
Yes.
All right. Rather than do an access easement, they've decided to do an access license, so to speak. Let me take a look at Exhibit 46 and see what it has to say about the site plan. Description of the site, Exhibit A. All right, so let's see. I should find some reference here to the exhibit.
Paragraph 4, Your Honor, page 4, paragraph 4 talks about access and utilities.
So here's page 1. Licensor does hereby grant. I'm just reading sentence 1, paragraph 1. A 60-foot by 60-foot portion of the property, which is hereafter referred to as site, and which site is more specifically described in Exhibit A, attached here too, together with the right to place upon it a facility. All right, well, you're right. Maybe we do need to go to more access. All right, paragraph 4 also grants the non-exclusive right of way for ingress-egress 7 days a week, 24 a day, on motor or foot vehicle, including trucks, utilizing Providence Height Loop Road, as depicted on Exhibit A. If any project will prevent them from accessing the site using the designated ingress and egress route, licensor shall notify licensee in writing in advance and make best efforts to designate an alternative. Any alternative must be agreed to. The licensee shall have the right to install and maintain conduits, pipes, utility lines, and wires, blah, 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 as depicted on Exhibit A. All right, so then we'll just go look at term and revocability here. Here's the 12-month term that Ms. Brown was asking people about. Term is automatically extended. Yeah, but it says pretty clearly in paragraph 5, final sentences, the parties agree and acknowledge that this agreement is being executed to allow a temporary communications facility with only a 2-year term, with the understanding that the parties will negotiate in good faith to finalize a long-term lease or license agreement that will permit licensee and sub-licensees to continue to operate from the property. The parties agree to commence in good faith negotiations on an agreement for the permanent site at the property within 30 days. So I mean, this entire agreement gives them, you know, a 2-year right to throw up a temporary facility. It does not appear to give them a permanent right for a permanent facility, you know, much less does it give them an easement for a permanent facility. What response do you have to that concern of mine, Mr. Yormick? Had you seen this thing before today?
The first time I saw it was a couple of weeks ago when it was provided with the documents, but I was not aware of this before then.
So prior to seeing Exhibit 46, what did you think the access plan was for the cell site?
Was to utilize the existing easements.
But the existing easements don't reach the cell site, so how are they going to utilize those?
I guess they can.
All right. Okay. All right, Ms. Soto, further questions?
None for this witness.
Okay, I will turn it over now to Ms. Brown. Ms. Brown, do you have cross-examination questions for Mr. Yormick?
I guess just one further question. Again, I'm looking at the Exhibit 46, a little further down on page 4, paragraph 4. It also states that the leases shall terminate effective on the day prior to demolition of the water tower. So this license appears to not, as I've said before, it's no longer in effect, and it only applies to this water tower business. So again, I would emphasize that I don't believe this permits.
All right. No, you're not testifying. Hold on. You're not testifying. You can ask a question of Mr. Yormick. You got a question for him?
I do agree.
Questions?
I just wondered if you had read that part, Doug, and realized that this only applied to the water tower.
That's argumentative. No, no, no. Ask questions. Otherwise, I'm going to stop your line of questioning if you do not do that, ma'am.
I think I need to go to law school.
I try to give the parties as much slack as I can, but I have to be fair to the city too.
You're right. I think I'll just not ask any more questions to Mr. York. He's clarified things clearly.
Very good. All right, so I don't think we had a question, Ms. Soto, so I won't give you a chance for, well, you can ask some follow-up because I was tormenting him with questions. You want to ask him any follow-up based on what I was asking him?
I have nothing further.
Okay, all right. Has your other witness appeared, Ms. Soto?
He has, yes.
Excellent. All right, let's hear the city's next witness.
All right, next the city will call Christian Geitz.
All right. Good morning, Mr. Geitz. Will you raise your right hand, please? Do you swear or affirm the testimony you give today will be the truth?
Yes, I do.
Thank you. Can you state and spell your full name for the audio record, please?
Yes, Christian Getz. It's Christian. Last name Geitz.
All right, Mr. Getz, are you with the city?
Not as of last Friday. So
Oh,
last
that's
Friday was my last day. So
What did you used to do with the city?
I am the former planning manager, current planning manager.
All right. Thank you. Ms. Soto, go ahead, please.
Former current planning manager.
Yes.
Thank you, Christian. I just have a couple of questions for you regarding process. So can you explain what the purpose of a master site plan is?
Sure. It's a overarching conceptual plan to approve and establish land uses, design, layout for larger projects, typically larger projects like the school, like larger commercial projects, to basically establish the blueprint for how future development in a phased process, because they're so large, they typically aren't built in one single building permit, how they are built over time with various conditions, requirements within the agreement.
And so the Issaquah School District project required a master site plan and a site development permit. Is that correct?
That's correct.
And can you explain what the purpose of a site development permit is?
Yeah, so the site development permit, yeah, looks at more specifically the building design as part of the broader master site plan. Master site plan looking at various buildings, but the site development permit is looking at design standards, gets into some more detail around what the type of use will be, parking layout, and sets the framework for what each building will look like. And the decision by Development Commission looks at, window glazing, sometimes it's architectural design, colors, down to artwork, maybe if it's required as part of that approval.
And so once an applicant receives an approved master site plan and site development permit, can they go ahead and just start building?
No, they would have to submit for a building permit, a construction permit that would then be reviewed for all of the structural elements, and then the land use piece. So every division, fire, building, engineering, and land use, among others, would look at their various pieces of the construction permit. And there's a whole slew of those. It's building permits, plumbing, mechanical, you name it. And that review gets into the finer details of what the final improvements will be based on the conceptual plans that were approved under the master site plan or the SDP, site development permit.
So you said that the MSP and the SDP are more conceptual. How do you determine then actual conformance with the Issaquah Municipal Code and those approved permits when you are looking at those other later land use permits and building permits?
Sure. We're verifying it, and there's a lot of detail that is provided with the master site plan or site development permit. And the building permit, the construction permit review is going to look at confirmation that the same square footage was proposed, massing, height, The plans are generally on a master site plan or a site development permit are 70 to 80% designed. And that final push is the final engineering, final structural calculations, making sure that's going to work. And so it doesn't always change what the building will look like. The shell should be about the same. Windows and doors are going to be in approximately the same location. And so that review specifically for land use, so the group that I manage, they'd be just verifying everything is looking the same. There's nothing out of place, out of the ordinary. But there can be aspects like building code that come in that might require a window moved, a doorway moved, and so we would verify that the intent was there for everything from ingress egress on the conceptual master site plan, site development permit, into those finer details of the construction applications.
So you just mentioned ingress and egress. Do you mean things like access to the site?
That can be one of them. If you realize once you're digging in the dirt and you find something that you've got to work around, soil types that you might run into something underground that wasn't anticipated for certain utilities, but more along the lines of a doorway or a walkway that might need to shift a couple feet because the wall structure needed to change for some reason that I'm not familiar with. So our review would just make sure that it was essentially consistent. It aligned with everything. They weren't adding new impervious surfaces, and landscaping all lined up as well.
So if you received some of those later permit applications and they were not consistent with the MSP and SDP and or SDP, or they changed the plan, how would the city typically handle a situation like that?
Yeah, sure. So if there are changes, there's provisions in the code in the process chapter for amendments. So there's minor or major. The threshold is, I believe it's 10% in the current code as far as if you are adding impervious surface. If it's less than 10% of the full lot coverage or impervious surface, driveways, parking areas, if it's less than 10%, it's a minor modification. If it was more than 10%, it would be a major modification, major amendment to that. So there's various process levels that would be followed, administrative versus going back to Development Commission.
Can I jump in real quick? Because I have a question about the timing of all this. All right, so you have an MSP that says, here's where you're going to put your cell phone tower. And let's imagine that there's some, condition in the MSP that later proves to be burdensome. And the hypothetical we've been using all morning is, there's a condition in the MSP that says you can't cut down even a single blade of grass. And then you get your ASDP for the cell tower, and it says you can cut down grass. In fact, you'll have to in order to build it. So there's an inconsistency, right, between the MSP and the ASDP. At what point does the MSP need to be revised to eliminate that inconsistency? And presumably that would be a minor amendment, as you've been describing. Do we have to revise the MSP first before we issue the ASDP? Or do we issue the ASDP first and then after the fact, we retroactively change the MSP to authorize what we've already approved through the ASDP?
Yeah, I believe it could vary. So it depends on the scale and the amount of time that it might take to do an amendment. The
problem I have with doing it after the fact is we've got some language in 18.04.520 that says, once approved, your MSDP, what does it say here? It says, upon City Council approval of your MSDP or development agreement, the property's development shall be governed by the substantive provisions of the approved plan/development agreement and implemented through other applicable permits. Okay, so the way I see it, you do your MSP. If it later emerges that you've baked something in there that's causing trouble for you and you want it gone, you have to amend your MSP first. Once you've amended your MSP, then you go ahead with whatever you were hoping to do through other permitting. That's how I read Section 520. How do you read it?
I would need to read through that, how it was.
And
how it was
that's fine.
written.
Yeah, it's perfectly fine. So, but we were asking questions about process. So this gets to the question that I was asking you. If it turns out that in order to implement your project, you're going to need to revise the MSP. Do you revise the MSP first and then issue subsequent permits? Or do you issue the subsequent permits first, and then once you're reading them, you're like, oops, we broke something in the MSP. Better go back and change it. Which is the correct process?
I believe you could do either with conditions. So a conditionally approved land use permit, because we're not building anything with an ASDP or any other land use decision, conditionally approved prior to either submittal or prior to issuance of a construction permit for the thing being built.
So that's a good thought. We do that in this instance. Does ASDP 22007, the one that's under appeal, does that have conditional language in it that says, hey, if we accidentally broke anything in the MSP, go back and fix it as a condition of approval? I don't think that's in there, is it?
I don't believe. I don't know if it is
right.
within that document.
So then if we don't have that, how do we resolve any contradictions between the MSP and the ASDP? What's our process for resolving contradictions?
Well, it would either be what I've seen in the past, either through this process, adding a condition that it be amended, or we have to start over and either amend the MSP or reissue the ASDP with such a condition.
Yep, I got you. Okay, all right, that all makes sense. Sorry for the hijack there again, Ms. Soto, but it just means I'm interested in your witness's testimony. Please go ahead.
So kind of along those lines, are you familiar with the ASDP that's at issue in this appeal?
Yes.
And are you aware of any inconsistencies with the ASDP and the MSP or the SDP that were issued for the school district project?
Not as far as the location of the cell tower. It was always listed, shown on multiple sheets within the presentation material from the MSP SDP, which was the decision was made before I began here. So it appeared to be consistent with I believe it was a 60 by 60 square for where the future cell tower permitted by others under this ASDP was to be located. And then additionally, the location is within, kind of identified separate from or within the perimeter buffer, the perimeter landscape buffer around the full site.
And so a quick question about ASDPs, like with the we already talked about with MSPs and SDPs. What's the purpose of an ASDP?
It is just the administrative land use approval identifying a proposal is consistent with the land use standards, and in this case, the land use standards subject subject for a wireless facility.
And are those the standards found in the former 18.22 IMC?
Yes, I believe this one is vested to those old standards.
Okay. I have no further questions. Thank you.
Thank you. Cross-examination by Ms. Brown.
I don't believe so.
All right. I think that was, did you have another witness, Ms. Soto? You told me only 2 before lunch.
Yeah, that is it for the city. Thank you.
Awesome. All right. Thank you, Mr. Gintz. All right, Mr. Bush, your turn for witnesses. Who have you got?
Thank you, Jennifer Taylor.
All right. Good afternoon, Ms. Taylor. I'd like to swear you in, please. Will you raise your right hand? Do you swear or affirm the testimony you give in this hearing will be the truth?
Yes.
Thank you. And can you confirm the spelling of your name? Jenniffer, last name Taylor?
Yes, that's correct.
Thank you. And are you with the city of Issaquah, ma'am?
No, I'm with the applicant from Links. I'm from Links Consulting here on behalf of Verizon Wireless.
Okay. Go ahead with your questions, please, Mr. Bush.
Great, thank you. Could you share your title and your job responsibilities?
My job title is real estate manager, and specifically I handle leases, easements, permits, modifications for cell sites.
Very good. And you've been helping with this particular application?
I have been, yes.
Great, thank you. We've been talking about the license agreement, which is Exhibit 46. Are you personally familiar with the commencement date and termination date of that license agreement?
Yes. It went
Could
into
you share what
effect.
that is?
Sorry. It went into effect on March 1st, 2022. And the 2-year term ended March 1st, 2024.
Okay. And so the license agreement was in effect on the date the ASDP was issued?
Yes, it was.
Okay. And is there a replacement agreement currently under negotiation?
It is, yes, still under negotiation.
Okay, thank you. And then when we take a look at the temporary license or the license agreement, it refers to a temporary site. And now this application is for a permanent site. Can you describe why there was a change from temporary to permanent, 85 feet to 150 feet?
So originally when the Issaquah School District provided notice that they were intending to take down the water tank, and they gave a very short time period of notice to remove antennas from the tank. And so the license agreement was put into place in order to put up a temporary facility, as that can be the quickest to construction to get a replacement site on air. Obviously, we've been 2 years into this now. We've had time to come up with the design for the permanent facility, and so that's what has been applied for since.
Okay. And at this point, there's no need for the temporary facility if this permanent site is approved.
Correct.
Okay, thank you. I have no further questions.
All right, questions from Ms. Brown, for Ms. Taylor?
If I understand, just one question. So if you're working on something, it hasn't been shared with the city.
No, the permanent license agreement that's under negotiation hasn't been shared with anyone yet. And it's actually not part of the city requirements normally to provide the lease agreement. That it wouldn't typically be something that we would provide them unless it became relevant or became requested. It's not part of the normal application requirements.
And would it include an easement?
I'm sorry?
Would it include a vehicular easement?
Yes, the permanent license agreement will include both the 60 by 60 area and the new permanent planned access easement, which will be clarified to show that it's routing through the north entrance of Providence Loop Road.
But it's not available yet, so it's not determinate for this. Is that?
It hasn't been fully signed and completed yet, no.
That's it, thanks.
All right. I don't think I have any questions for you either, Ms. Taylor. Thank you so much for your testimony. All right, Mr. Bush, do you have anyone else for us?
No further witnesses, thank you.
Very well. In that case, we are, oh, wait, I promised Ms. Brown a chance for rebuttal witnesses. Ms. Brown, do you have any rebuttal witnesses you would like to call? Witnesses to rebut what we have learned from other witnesses?
Yeah. No, but I don't.
All
I
right.
would like to ask for 5 minutes before we do any closing statement.
That seems reasonable. Yeah, and we've been going for, I guess only about 45 minutes, but yes, let's give everyone, you've all been so efficient with your time, I'll give you 10 minutes. Why don't we come back at 1:25, we'll do oral closing arguments. The order will be appellant, city, applicant, and then last word back to appellant. I'm not going to set any time limits on you. You've all been very efficient. Issues that I'm hoping people will address in closing. First is, I never heard any testimony on exhibits 16, 30, and 32, so I'm assuming that I will be striking those, but maybe I'll let Ms. Brown correct me if there has been witness testimony on those 3 exhibits that I just didn't understand. So that's one thing. Another thing I'd like the parties to address in closing, Ms. Brown, if this is kind of your last chance to decide, are you going to do anything with wetlands or stormwater? We've heard no testimony on it, and it wasn't in your opening brief. But you don't only have to rely on testimony in these proceedings. You can rely on the documents too. If you're going to give me an argument on wetlands, I'd like to hear that argument with some citation for why it's illegal for them to build the cell tower in the wetland. If that's where you're going. Believe me, I'm not encouraging you to throw more issues into your appeal, but that's a live issue, and now is the time to do something with it if you plan to. Other things that I would like. So as we've heard from my back and forth with some of the witnesses, most recently Mr. Getz, I am, just procedurally, I kind of wonder if your MSP says to do or not do a certain thing, and then your lesser permit, your ASDP, either breaks that condition. Is that grounds to reverse the ASDP, or can we kind of retroactively modify the MSP? Or is it the case the MSP must be modified first, and only once modified do you get to do your ASDP? But that's only in the event that there's a conflict between whatever the MSP says and whatever you're planning to do in your ASDP. If there is no conflict, obviously, then I'm worrying about nothing. So what I'd like to hear from the parties in their closings, is there a conflict? The MSP has got some vast number of conditions. I just had it up a moment ago. What is it? 33 was that is that the MSP?
58. 58.
Yeah, right. So here's 38, and then it's got 58 different conditions. And I just wonder if one of these 58 conditions says something that would prohibit the issuance of the ASDP that's under appeal. So I don't know that there's a conflict, but if there is, one of y'all can tell me about it, presumably Ms. Brown. And then if there is a conflict, then I'll need to hear some argument, procedurally, what do we do? Is it acceptable to retroactively fix the conflict by amending the MSP, or do we have to fix the MSP first and only then do we get to do the ASDP? And when I say argument, I would appreciate some citation to, the municipal code so I can actually see what the process is. So that's one of the issues. Another issue that I'm hoping the parties will address in their closings is the requirement in the easement decision, which I think was Exhibit 7 to Exhibit 1, so to speak. So condition 1, sorry, this is the variance decision. The variance decision, Exhibit 7 to Exhibit 1, condition number 1 of that variance decision says prior to issuance of ASDP 22-0007, the applicant provides their access easement to use Providence Loop as access to the lease area or revise the access location to a different location. I want to hear from the parties. Have they done that? Did they provide an access easement, or did they revise the access location to a different location? Presumably Ms. Brown's answer is going to be no, because if you look at the access easement, it's easement 18 there on the site plans, which I think we ended up using Exhibit 36 for that. That's not right. What did we end up using for that site plan, Ms. Soto? What exhibit was that?
That was Exhibit 36.
Oh, it was 36. Okay.
It was the landscape plans that showed.
No, but you had one where there was like an 18 with a triangle inside.
Oh, yeah, that's exhibit. That's core document 1, exhibit 2 of that document, the plan set.
That's more like it. Yeah, and I think that's the final official plan set for the ASDP.
Correct.
So I want to know, does that easement go to well, holy smokes. All right. Do we have who is testifying on this? I might have to call a witness back here because I just observed something. Who'd be the one on this? Maybe Mr. Yormick. Can we call him back?
Yeah.
Ms. Soto, can you share a screen of Exhibit 2 plan set PDF 3? And I've got questions for Mr. Yormick. Sorry about this. I know we were done with witness testimony, but the closing arguments haven't started, so no harm done. Yeah, all right. So, Mr. Yormick, when I was questioning you, I had this problem that the easement that's labeled number 18 does not connect to the square where the cell phone is going to go, right?
Yep.
All right, but go down to the very next page. Wait, this is wrong. Go to page 5, so 2 more pages. All right, look at this. What is this showing? This seems to show some solid gray material that does connect to the to the site. What am I looking at here? Am I looking at the missing easement, or what is this thing? I don't think I am.
It's not labeled, so I'm not sure why it is in gray like that.
Yeah, the easement doesn't actually, the easement itself, the 1997 easement doesn't say that because that square didn't exist in 1997, right?
That's correct.
All right, false alarm, we can take it down. All right, so I want to hear from the parties. So I guess it is a live issue then. Did the applicant provide their access easement to use Providence Loop as access to the lease area? And presumably Ms. Brown's answer will be no. Look at the 18 with the triangle in it. It doesn't reach the square. But presumably Mr. Bush's answer will be, well, actually, at the time of the decision, which is the time that matters, at the time of issuance, they did have this license agreement, the Exhibit 46 agreement. The potential problem with that argument, Mr. Bush, is going to be by its own terms, it's not an easement, it's a license, and it specifically says this is for your temporary cell phone tower. But this permit application is for a permanent cell phone tower. So if you're going to say, we met that condition in the variance, we did the license agreement, I'll want to hear argument from you, sir, as to why this a temporary license is the same thing as a permanent easement. And as we just heard from Ms. Taylor, this is gone now, and they're trying to renegotiate it, and it might end up being different. She even said it might be coming in from the north. So, this is the problem with temporary things. They expire and you can't really rely on them. And that's why it makes good sense to me to make sure that you have the access easement. I thought that condition number 1 in the variance was, its heart was in the right place. So that's one of the issues I want to hear argument on. Something that we didn't talk about with any of the witnesses really was clearing of vegetation. And I thought that was going to be such a big thing in this case, because it's like 3 different issue statements from Ms. Brown were all about the vegetation that's going to be cleared and why that's potentially unlawful. I don't think I heard one word from any witness as to whether any trees were even going to come down, and if they were going to come down, whether they would be replanted. So one thing I want to hear from the parties is that issue just dead, or am I supposed to rely on something in the documents? What are we doing with the destruction of trees here? I really have no idea. So I think that's all the questions that I still have in my mind. So that'll be for folks to address. I realize I've now taken up all of your prep time. I'll still give you your 10 minutes. So why don't we come back at 1:35 and we'll hear from Ms. Brown. But these questions that I've raised are really for everybody. They are, there are potential weaknesses in the cases of all parties. So I'm interested in everyone's thoughts on every question. All right. Thank you so much. 1:35. Okay, folks, 1:35. I think we are ready to go back on. Are we still recording?
Yes.
Excellent. All right, let's go ahead with the closing arguments of our appellant, please. Well, maybe we should wait for the city attorney to show up.
I'm here. I just did not have my camera on.
Oh, okay. All right. Ms. Brown, are you ready to proceed?
As ready as I'll ever be.
All right, let's go to it. And now is your chance to tell us what you think is legal and not legal and how credible any of the testimony is.
And I'm not sure whether to follow your order or the order you asked me to do earlier on, but I'll try to follow your order and correct necessary. First, in terms of the conditions and so forth of the city council decision, I believe a good way to look at this is look at the totality of the conditions. in the master site plan and others, clearly it leaves space for an undisturbed buffer. And in particular, you might want to look at condition 7 there, where it talks about a native growth protected easements.
All right, I'm going to take a look at condition of approval number 7, and this would be from exhibit 33. All right, I'm scrolling down, number 7. It says that prior to the first building permit, the applicant has to record a native growth protection easement or similar instrument over the resource protection community space. The problem with this line of argument, though, Ms. Brown, is that, first of all, we're not at the building permit stage. So to accuse them of violating this condition is premature. We don't know whether they will or will not record an NGPE. The second problem with it is the square where the cell tower is supposed to go appears on the site plans that were under consideration at the time of the master site plan. It's even in the staff report for the master site plan. So, you know, given that they've kind of carved out this square inside the buffer, I don't think you get to say, well, the plan generally calls for a buffer. Yeah, generally it does. A buffer with a square carved out, and that's exactly what they're doing. So where is the inconsistency?
I don't believe that the master site plan, well, the buffer, where is the inconsistency?
Yeah.
I believe that the square, again, was for something that was proposed, not permitted yet. It said to be permitted in the future by some other agent. Therefore, it was not considered serious at the time of the city council decision. It was not discussed at all and considered as just simply not a part of the permitting at the time. So nobody really took that square seriously, and it shifted space too. I remember seeing it one minute it's sort of up by the buses, the next minute it's bigger. So I do not believe that it was anything that was contained in the city council decision.
Okay.
That's the closest I come.
All right. Have I lost audio? Is Ms. Brown still talking?
I'm just waiting. Should I go on to?
Oh, yeah, absolutely. Yeah, it's your closing. Yeah.
The next thing is about the square, and I think I just described that. My sense is that it was proposed and not serious. I'm also concerned that there was something ongoing that was known that was not that was concealed. But you can take that as you wish.
Yeah, I mean, that might be grounds for reversing the MSP, but that's not the decision that's on my desk.
Well, or perhaps reversing the ASDP. But in any case, pretty expert on this.
Well, it's your case. I mean, you tell me what grounds for reversing the decision are.
As far as code, next, you asked for the master site plan, and as we've all discussed, it clearly is in chapter 1804.520 and 1804.530. And as you already cited, that the city council approval and so forth, that implemented through subdivision, short plans, and so forth. And then the last sentence I'll just bring out, any conditions or standards of approval for any subdivision, short plat, binding site plan, or other permit or approval for the property shall utilize and incorporate the development standards set forth in the approved plan.
I quite agree. And that's why I was asking you, is there any inconsistency between the approved MSP and the ASDP? And the inconsistency you pointed to me was kind of a general rule for an undisturbed buffer, and then the language of condition 7.
I did bring out other inconsistencies,
All right, what have you got?
quite a few, in my appeal in the opposition.
All right, can you, I don't have those on my screen right now. Can you remind me what other provisions of the MSP you believe are inconsistent with the issued ASDP? I can fall back. To your brief.
Yeah.
There's so many. Can you give me one?
Yeah, okay. Again, I will bring up the stormwater that I believe is still alive.
Well, hold on. I'm not quite ready to go there yet.
I agree.
I'm asking a much smaller question right now. Is there something in the MSP that says the city's not allowed to issue the ASDP that it issued? Will I find that somewhere in this MSP?
I'm sorry, you can't find it because the ASDP for a permanent 150-foot cell tower did not exist. Had it existed, it would have been a very serious concern.
I know, but it's depicted on the site plans, ma'am. So other than that, what other provisions of the MSP would you like me to read that would lead me to reverse this ASDP? It is your burden to read those provisions to me right now. And if they're already in your briefing, you can just say, well, just go back and read my briefing. But I just, I'll even call up your brief right now.
I would like you just simply to accept the fact that they're in the brief.
All right, that's fine. And if you have no further argument on it, that's fine. The brief too is part of your argument. So that's a perfect.
I'd like to look as well at the objection to the motion to dismiss. Oh, and my original appeal.
All right, so I'll check your notice of appeal. I'll check your pre-hearing brief. It's kind of alarming to me, ma'am, that this is your closing arguments. This is the phase of your case where you're supposed to tie it all together. And other than condition 7, you're not pointing me to any other inconsistencies between the MSP and the ASDP. If you really feel like you don't have another word to say on that subject, then so be it. But
as I said, I will mention the stormwater and here.
All right.
First to ask for also, well, yeah, it's not only that, there are violations of requirements in the IMC, Issaquah Municipal Code, which was asked for, and there are violations there as well.
Can you be more specific?
I'm very tired, I'm sorry.
No, it's been a long day of land use, I'm sorry.
Yeah.
But
Yeah.
this is the big moment, Ms. Brown. I mean, this is, and we can take a break if you'd like a longer break, but this is really where you've got to hit it out of the park. So
maybe if I could have just 2 minutes.
Well, why don't we do 5 minutes, folks? We'll come back at 1:50. That's 150, and we'll hear more from Ms. Brown. All righty, folks, we're back from a little 5-minute break there. If I can see our respondents, we'll resume with Ms. Brown as soon as I know that everyone is here to hear her. All right, there's Ms. Soto, and there's Mr. Bush. All right, Ms. Brown, go ahead with the remainder of your closing, please. I'm not hearing any audio from Ms. Brown.
Okay. Okay, so as far as what you're asking for is contradictions of the conditions in the master site plan with if there still are some, well, we go back to the same ones we've been discussing. The master site plan does not allow access or easement to the road by way of the loop road. And I could get into detail with that because the reason it's for emergency access only is because the entrance at the loop road on 228th Street is only 1,200 feet from the subsequent entrance
Hold on. I'm going to need some citation in the record for that. So there's no testimony on that point. If this is going to, in your closing argument, I'll need a citation to something in the record that supports it. I'm not just going to allow you to introduce new facts that we haven't yet heard. So citation to record, please.
Is in the staff report study.
All right, Exhibit 15.
And it's also in my.
Wait, where in Exhibit 15? Exhibit 15 is 177 pages long.
This is a complex, yeah.
Well, I know, but at the same time, these are your arguments, ma'am, and you know, this is the time that you have to make them.
You're asking me to summarize a year and a half.
No, ma'am. I'm asking you to find a citation in the record for the argument you just put forward that there's some kind of width reason why the easement has to be a certain way.
Yes. I apologize for the delay.
No, it's all right. And if you don't have a citation for it, that's fine. You know, you can just move on to some other subject. I'm not trying to, turn this into a torture session here, but at the same time, I need to know what the arguments are, what the basis in the record for those arguments is.
Oh, I know. It's in a condition. I apologize. It is in a city council condition.
All right. So this would be Exhibit 33.
And this is very clear. It is condition. Okay, 23 but there's another.
Condition 23 says a gate shall be installed at the entry to the high school.
Okay, that's it has to do with emergency. Well, condition 9.
All right. Condition 9 says applicant shall install a vehicular gate at the south end of the proposed fire lane on the eastern side of the high school. The vehicular gate shall be equipped with a Knox box or what is this, ma'am?
This is actually the fire lane where they're saying that they're coming up with a new easement from the interior. If you look at the site plans on the school property, that is designated as a fire lane. So they would not have access by that either.
I don't understand this argument, but I'm not going to keep tormenting you with questions on it. It's your argument to make, and if I don't get it, I mean, I don't get it.
I'm sorry, I did not know that we were getting into site plan. It is is here.
All right.
And I had it, I've read it 1,000 times, but of course, yes, I have it.
Okay.
On page 153.
Exhibit 33. No, that can't be right. Page one.
Now I'm to exhibit 15. This
All right.
is
Exhibit 15, page 153, you say? Okay. I'm there. What am I looking at?
You're looking at number 3, paragraph 3, toward the bottom.
Deviation. Is the paragraph titled deviation, ma'am?
Yes, it is.
All right. What would you like me to learn from this paragraph?
I'd like you to realize that the entrance by the easement they had, that they are saying they have now, would in and of itself not be possible, because a deviation had to be allowed simply to allow emergency access. And I'd like to read the sentence. The City of Issaquah Street Standards Design Section A as it relates to the
Hold on, and I am interested to have you read the street standards in just a moment.
So
Wait. I have a question. I'm reading the deviation paragraph and I'm reading it again and again.
I would just bring out that the standard is.
Wait. I have a question for you. So I'm reading this deviation and over again. I'm not sure what emergency access point we're talking about, and it looks like the deviation is that they're providing less than the standard spacing between the arterials for some emergency access. I am utterly baffled, ma'am, as to what this teaches me about why the ASDP was rightly or wrongly issued. Can you explain the relevance of any of this? And then we can talk about street standards if those are relevant at all.
Thanks for the clarification. Yes, it's relevant because the easement along the loop road that they claim to have cannot be used without a deviation.
So what?
They have no deviation and it's for emergency only.
Well, but the condition in the variance condition number 1 was merely that they provide an easement. It was not a separate condition that said easement must be consistent with, road standards absent the issuance of a deviation. You're reading requirements into the variance condition that I do not believe are there.
I'll leave that to the specialist, but I do believe that an easement to provide an easement, one would have to be aware of the conditions for providing such an easement. And so a condition is that if the utility trucks and diesel fuel and all were to come in through the loop road, a deviation would have to be provided for that. And I do believe that would be a condition.
I don't know that the evidence you've cited supports that argument. This deviation paragraph that you had me read on page 153 is not discussing the location of the 1997 easement, is it? It's talking about a completely different access point on the east side of the high school, isn't it?
This is what is proposed in ASDP 22. Use of.
What? No, it isn't. You've lost me, ma'am, and I know that you are very familiar with this record, and I am not, so I'm probably the one that's making a mistake.
I know.
On page 153 of Exhibit 15, I think there's a deviation proposed. For the driveway that the school buses will use.
No. Well, no, this is a deviation for entrance off of 228th.
Let's do this, ma'am. Why don't you call up a map that's in the record and show me the location of this deviation, please?
Let's look at the ASDP.
All right.
See there?
What exhibit number?
Exhibit number Page 31, let's see, this would be,
Page 31 of what?
the site plans.
All right, so that's Exhibit 2 to Exhibit 1. All right, these are the site plans for the ASDP. You want me to look at page 31 of them? I am there.
Sure.
And where is the deviation that you were just describing shown here on, wait, page 31 is a cover sheet, ma'am. Now I'm worried I'm in the wrong thing.
It's it's land use, let's see. It's a site plan, the one we were just looking at, with all the dots.
I'm sorry, ma'am. You've lost me again. I need an exhibit number and page number if you want me to look at a particular map.
I don't want to get into the weeds yet. It's this page.
Can someone help out Ms. Brown there? I don't care where this comes from. I just need to find the map.
I think she's going to back to the, that landscape plan that we were looking at that.
Exhibit 36. Is she on Exhibit 36?
Yeah,
No. Will this show what you want?
no,
Is it in this plan set?
yeah. But
What sheet number does that say?
sheet 6. That's,
Let me
yes.
see if that's on here.
Can someone tell me what exhibit to look at, please?
Just 1 second, I'm confirming that we're in the right plan set together. And I don't think we are. I don't have a sheet 6.
Are we referring to the core document 1, Exhibit 2, the ASDP plan set?
I thought at one time we were referring to that, but page 31 of that document is merely the Verizon Wireless cover sheet. It does not show any kind of map. And I thought she was going to show me a map.
This one I have a 6 on. Let's say it would.
No,
What other, is there another number down there? No. It's a proposed utility sheet on something.
I'm sorry. I got to go what's in the record.
Hold on.
I'm getting back there, sorry. Oh, Jesus Christ.
Number 6.
No, that's only for the, I'm looking at the map for the hearing examiner.
And do you know where you got this out of?
Yes, it's out of the site plan, the 6 pages that were followed, that followed the notice of decision.
6 pages that it followed on the notice of decision. Doug, do you have that?
ASDP 22.
What was that again?
She said it's like the 6 pages that's were attached to the end of the notice of decision of the ASDP.
Yeah, I'm going to assume that's the plan set.
Thanks, Doug.
Is there a 6 on page 6 on that?
Yeah.
All right, Mr. Yormick has helpfully called up a document here. Why don't you tell me what exhibit number and page number you are in?
I am in core document 1, Exhibit 2 of that document. It's the plan set that was an exhibit to the notice of decision for the ASDP cell phone or cell tower project.
Exhibit 2 to Exhibit 1 is a 102-page document. What page number of that are you on?
My apologies, page 6.
I don't believe that's the same as this, but
All right, I'm now looking at the same page that Mr. Yormick is displaying. It is indeed page 6 of Exhibit 2 to Exhibit 1. Now, Ms. Brown, you were saying that you had this citation in the staff report for the master site plan. It said that a deviation would be required for emergency access somewhere on the property on the eastern side of the school, which this is not showing now, this exhibit 2 of yours. I am baffled about what your argument is at this point.
This is not the same one. But
I agree.
I will explain that if you look at that road at the bottom, that is where they claim to have an easement and access.
Yes. And to be more specific, the easement, as I understand it, the existing 1997 easement runs approximately, oh, look, it says existing easement right on it. Do you see where it says existing easement?
Old, but still.
Wait, I'm asking you a question, Ms. Brown. Do you see on this document that you are relying on where it says the words existing easement? Do you see that?
Yes.
All right. So what are you hoping I learn here?
I am saying that if you were to follow that road to the right, this is not the same document as the one I'm looking at. The one I'm looking at is a much larger one.
It is incumbent on you, ma'am, to rely on evidence that is in the record. So either give me something that's in the record or make do with this.
And could you go one page further on that? Maybe Doug? It's a.
Doug, can you flip through that?
Okay, well. There it is. Okay.
All right, Mr. Yormick, what page number are we on with Exhibit 2 of Exhibit 1? Mr. Yormick. Not hearing from Mr. Yormick. Somebody in the room, shout out what page number they want the hearing to look at for these closing arguments.
It is Exhibit 2 of Exhibit 1, page 5.
Thank you.
Yeah.
No, mine is different. I am in Exhibit 2 of Exhibit 1. I am on page 5 of 102. What page number are you on?
Page 4. Sorry.
Page 4. All right.
Yeah.
We are on page 4 of Exhibit 2 to Exhibit 1, and it does look the same. Ms. Brown, before we move on to this, and I'm getting a little bit exhausted with it, what do you want me to take away from all of this?
I'll make it quick so we can move on because I do have some points.
Yeah, this is not your argument.
Simply,
I mean, at least it better not be.
The geography. If you follow what's called the Providence Heights Loop to the far right, you see the entrance to 228th Avenue.
Yes, I do. And I assume that's going to merge with 228 to the far right, in the upper right corner. Yeah. Oh, wait, I see what you're talking about. Yeah,
In the lower right corner.
Yeah, I got you.
Okay, all I'm saying, and this is really quite a minor detail, but that is where a deviation would be needed for access. And this is where.
Wait. You're saying a deviation would be needed in the lower right corner there. That's where deviation was. Wait. That's where the deviation would be needed according to your interpretation of staff report page 152?
Yes.
Okay. What is the point?
And the point is that the easement that is being used, if it's being used, would be on that loop road and would have to go in through 228. So that is reserved for at this, so they would need a deviation. And it's for the contradiction. It goes back to what you were asking, the contradiction with the master site plan.
How is that a contradiction, though? I mean, the master site plan itself announces to the world that there will be a deviation. And now you've proved that they need a deviation. You've just proved that they are consistent. You haven't proved a contradiction, have you?
Yes, because the deviation is for emergency vehicles only, not for communications traffic.
All right, let's
That's my point. We're finally getting to it. I appreciate your pushing me on this.
Well, I don't agree that the deviation is for emergency vehicles only. That's not what page 153 of Exhibit 15 says.
It says will be converted to emergency vehicles only.
The existing access will be converted to emergency vehicles only.
And a deviation is required. The request has been approved.
Ma'am, I'm not even convinced that this deviation paragraph is talking about the same segment of road that you have displayed on your map there. How do I know that that is the case?
I've been with it for 3 years and
Well,
it is. It's.
All right, that's not good enough. You've got to type in the.
Providence Point Drive Southeast and the existing Providence Heights Loop driveway at 228.
So there's the intersection of the two. Okay, the standard is 2,600. The existing fee is 1,200. The standard allows for less than minimum if the access is limited to right in, right out. Okay, the existing access will be converted to emergencies only with full access during emergencies, and a deviation is required. The request has been approved with the emergency access only mitigation. And your point based on all of this is, regardless of whether they have an easement or not, that whole intersection is now for emergency vehicles only, and no one else, including cell phone company trucks, can use it. Is that basically the argument?
Yes.
Yeah.
Okay, all right. Next argument, please.
Thank you. I'm sorry it takes so long. Yeah.
Safety.
And that is a safety issue, yes. Another contradiction which I brought up is that in the study in the staff report for the master site plan, as I spoke with Minnie Dollawall about, there is only information on a cell tower on wheels. There's no indication of where that would go and no discussion whatsoever of the square.
That's not true, ma'am. On page 159 of Exhibit 15, it says a temporary cell on wheels mobile cell tower platform may be placed on the site. Any new temporary or permanent equipment, ma'am, will be installed by others using a separate SEPA process, administrative site development permit, and building permit applications. Doesn't that contemplate the installation of permanent equipment right there in the staff report?
But it does not give the site.
Well, all right, but you scroll up in the staff report and you see the site. It's the square. It's right there on the maps. It's in multiple places. Page 57, page 52.
And it's proposed. It's not permitted. So I do not.
Okay.
That's my argument.
Okay. All right. Okay.
Based on a number of these things that we've been before, so I'll just continue with my closing
All right.
arguments. There is code, as you asked, for and I recommend that it's entitled 18.04.500 and 18.04.520, that those require that the hearing examiner really remand or deny the application. And because the master site plan does control it, and there are too many contradictions, and it also violates a number of requirements for disturbed vegetation and the buffer zone.
All right. So we heard no testimony on violating the disturbance of the disturbance of vegetation rule. Nothing on vegetation. So what are you relying on here?
I am relying on a number of things, and perhaps in my appeal itself. Also.
Well, so your appeal itself is not evidence. What evidence in the record, either testimony of a witness or the 44 admitted exhibits, because 3 of them did not make it in, what evidence in that body of documents and testimony are you pointing to right now? And I don't want to do another thing like we just did where it's like, you know, half an hour to track down a less than persuasive piece of it. I'm gonna ask you to kind of move it forward here with the evidence. You know, as I say, you're familiar with this body of evidence. You should be able to show me where it says they're not allowed to chop down trees and they're chopping down trees.
Here I am pointing to IMC 1822.010B.
Yes.
Site plan, minimize visual safety, aesthetic, and environmental impacts of WCFs on the community.
All right, so 18.22.100, and I'm going to go there with you. It's helpful to read these things together. All right, so 100, and then you want B, towers and poles, yeah?
010B.
Oh, 010. Okay, that's not the citation I was expecting. I don't have a 010. Which version of the code are you using, ma'am? The current version or the version that was in effect at the time of this proposal?
In effect, the vested version.
Okay, we have a problem. The version of the code that I think controls this case has 18.22.100. And then its next section is 18.22.110. I do not see 18.22.010. I'm going to go to, and let me just ask you, Ms. Brown, are you aware that the code has changed? The code that you find on the internet is not the correct code. Are you aware of this?
Not only that, I participated in helping.
All right. And so your citation is 18.22.101. I want to make very certain that that is the citation you are calling me to.
It's 010.
010. I was doing 101. All right. Sorry about that. It was my mistake. I'm glad we checked so thoroughly. 010. Okay, we do have that. Purpose. Yeah, that's the section? Okay, I apologize. I had the numbers wrong. It was my fault, not yours. All right, purpose. What would you like me to see?
Well, for one thing, minimize visual safety, aesthetic, and environmental impacts on the community.
Okay.
And by establishing structure, integrity, and compatibility.
Wait. Now I'm confusing it. Sorry to do this to you.
That's all right.
18.22.010. Purpose. The purpose of this chapter is to, and then I have A, B, C, and D. Which of those letters do you want me to read?
E.
B. Promote the health, safety, and general welfare of the Issaquah community by regulating the siting and design of WCFs. Did that sound right?
Nope, that's not what I got here.
No, I know it's not. So we do have.
That's one more.
All right.
That's
18.22.020. 0. A. The goals of this chapter. All right, we've got purposes and goals. The goals are A, minimize visual safety, aesthetic, and environmental impacts. Okay, so that one I think was on you. The first one was my script.
Okay.
Okay, I see the goal.
Yeah. And then we have 020A as well, and minimize and compatibility. I was arguing in my appeal throughout that the proposal is not compatible with the neighborhood.
Oh,
Secondly, 020A, the towers, or A4, I'm sorry, I'm going to go down, 18.22.090.A4.
090A4. Let me see here. 09. These are siting criteria. A is for macro WCF, and 4 is located in setbacks. Yeah.
Towers must be integrated through the location and design.
Wait. You're going too fast again. 18.22.090 siting criteria. Subsection A. Major macro WCF locations. 4. Located in setbacks. Ma'am, have I followed your citation correctly?
Yes.
New poles shall not be located in any zoning setback area on private and public property. Ma'am, have I read your citation correctly?
I, um,
where,
I am citing.
wait, is your argument that the tower is in a setback? Is that your argument, ma'am?
Yeah.
What
I
is
am
your,
arguing that the tower must be integrated through the location and design to blend in with the existing characteristics of the site.
ma'am, hold on. I do not understand your citation to 18.22.090.A.4. I do not understand. Did I read the wrong citation? Did I hear something wrong? I am really trying to understand what you are saying, ma'am.
I appreciate that. And I think what's happening is that we are dealing with a code that's been updated and so forth. So I'm going to.
You didn't want me to read the setback rules, did you? That can't have been your argument, was it?
No.
So
Okay.
there's a screw up somewhere, right? Where's the screw up?
I have to find my 18. Oh, wait. There we go. Okay. 18 finally. Okay, so I do apologize. I'm very tired. I did not know that this was going to be quite so detailed. 18.22.100 macro towers.
Okay.
And this is let's look first, if you will, please, at 18.22. Let's see. Yes, 100
Design requirements.
design requirements. And we go down to 3 macro or small wireless antenna.
That is A3, macro or small wireless antenna.
B,
Antenna and related equipment shall be placed and treated to present the least possible visual impact to the public. Treatments might include, and then a list of treatments. Is that what you want me to read?
I'd rather, yes, that's possible.
Okay.
Read it. Yeah. But let's go down to B. I would rather not you read that. You can if you wish.
18.22.100.B, towers and poles. Now what?
Macro powers.
Number 1, macro towers.
Yes, B.
Preserve existing on-site vegetation and minimize disturbance of the existing topography unless such disturbance would result in less visual impact of the site to the surrounding area. Is that what you wanted me to read?
Precisely, yes.
All right.
I believe that there is a violation here.
Explain the violation using evidence that is in the record only.
The evidence is in the application for the administrative site development permit.
Exhibit number and page number.
Well, it's the permit that's being appealed.
I'm all right, ma'am. If there's something you want me to read, it is on you to direct my attention to that location. I am not going to cull through the record looking for evidence that might support you. You've got to direct my eyes. I know it's a painful process, ma'am, and I am trying to be very patient with you. I'm trying not to leave you floundering and without an argument. I want you to make the best possible case you can, and that is why we are doing this.
And I must say, I did not know that for the appealed document, I would have to give the exhibit number.
Are you saying the notice of appeal that you filed with the hearing examiner? Is that what you intend to rely on, ma'am? Is that what you are looking for at this time?
That I'm looking for the notice of decision on this.
So it would be Exhibit 1, core documents.
Yeah.
Okay. What do you want me to see in this with regards to vegetation?
The fact, I did not pick out a specific wording, but the fact that we have a 60 by 60 foot area plus 3 feet outside of that, that is all going to be graded, all trees removed. It will be a huge gash, if you will, in the hillside. And
But
that,
what is your evidence that all trees will be removed and it will be graded and become a huge gash in the hillside? I do not see any of that in Exhibit 1. I just don't see it.
I do believe it's a responsibility to see that throughout there are plans, and in the site plans for a 60 by 60 concrete surface impenetrable in this location.
Is it a concrete surface 60 by 60? I don't see that here in Exhibit 1.
It's in the site plans.
I'm not trying to be difficult, ma'am. I am trying to be helpful, but maybe I should stop.
Well, the application calls for, if you look at the site plans and throughout, there is a 60 by 60 concrete platform on which 4 buildings, 150-foot tower, a generator, and so forth will be placed.
All right, ma'am. Continue with your argument, please.
Contradicts what is allowed in the code I just cited.
Very well. Any further issues?
Well, I'd like to move on to simply, if we look, I wanted to get back to the site plan, no, to the 520. This very difficult. That, give me 1 second here. And again, I apologize. I did not know that we were going to be this specific, but I will appreciate it. There it is. No. Okay. Here I am. Okay. I would like to get back. To to 18.04 500. I believe that's it. Yeah.
1804 500 purpose.
Or 520 and so forth.
520 subsequent plat and permitting. Okay.
If you look at that, and moment, but if you look at that, it calls for, here we go. Okay, here's 18.04 520. The law is, of course, that it's needed, master site plan, but second, in terms of an amendment, I do believe that this is a major amendment that would be needed. And for a number of things, including the 150-foot tower. And that the amendment does need to be, and I'm citing B here, major amendment shall be reviewed, and that it must, and C, it must be made by the individual property owner. So if this were to be remanded, it would go back to the property owner to request amendments. I'm just bringing that out as an additional closing statement. And I'll go on. My final stormwater.
All right, stormwater.
Asked about the stormwater. I do believe it is still a part of my appeal. And then I will simply say that I would like to rely for that upon the appeal itself.
When you say the appeal itself, are you talking about the notice of appeal narrative that you filed?
I appeal to the ASDP 22.
The November 14, 2023 appeal.
Yes.
All right. So that document does not cite any of our exhibits.
I relied. It does. If you look under 2, this is the planned fill-in and stormwater treatment.
Wait a minute. So I'm reading your notice of appeal now, right? Your November 14 filing. Is that what I'm reading right now? Okay. And you wanted me to go to page 2, which I'm now looking at.
Page 3.
Page 3, which I'm now looking at. And page 3 begins with the words an existing erosion hazard boundary. Am I looking at the correct page 3?
Yes, you are.
All right. What should I look for on page 3?
Now to Roman numeral 2, please.
Roman numeral 2, planned fill in and stormwater treatment resulting from existing wetland C not addressed. Yeah. Okay. Now what am I looking at?
Okay. The second sentence under A.
Impacts will be permanent and wetland C cannot be restored. Okay. And the citation. Wait. And the citation to that is PRJ 19-0008. I will generously assume that that is exhibit 33. Is my assumption correct or is my assumption incorrect?
It is exhibit 15.
Exhibit 15 is the staff report, ma'am.
Yes.
So you want me to look at the staff report, page 106, yeah?
Yep.
Okay, I will look at staff report, page 106. What is your argument?
I will do the same.
Okay. I mean, the staff report says they're planning to fill in the wetland. Is that what you want me to take away from this?
Yeah.
Why is that illegal?
I'm saying there's a contradiction here.
What do you mean? A contradiction between what and what?
The proposed cell tower siting at ASDP 22 and what is stipulated here.
What is stipulated on page 106 of the staff report is that the wetland will be filled in. What the plans in ASDP 22007 say is to fill in the wetland. So it seems that both documents are loudly advertising that the wetland will be filled in. I do not perceive a contradiction.
ASDP 22 does not plan to fill in the entire wetland. They can't possibly. It's a huge wetland. And I mean, it's long, and they mitigate for it through payment, but the wetland is still there. And the only thing they plan to do is put in a driveway across it with a culvert under. So
are you sure they don't plan to put a 60 by 60 foot pad on top of it with a cell tower?
that's the wetland goes down the very side of it. It goes under the driveway to it. And then it goes along where they plan trench.
I'm really hesitant to ask this question, ma'am, but is there something in the record that shows the wetland in relation to the cell tower 60 by 60 pad? Do you have a document that shows those two things side by side? If the answer is no, then please just say no.
There is one, but
All
I'm
right.
not going to take your time right now to show it. But it's clearly that the wetland is a part of this permit.
Okay. I'm still trying to see what was inconsistent here. The MSP says they're going to fill in the wetland. The ASDP says, you know, we're going to fill in part of the wetland. Is that the inconsistency that you identified? They're not filling as much of the wetland as they promised to fill?
Beautiful. Yes, that's the idea. They plan to fill in enough for the driveway. However,
So if they filled in more wetland, you would be more satisfied?
yes, because they're supposed to. If they don't fill in the wetland, there's a serious issue of stormwater drainage. You see,
Okay.
the whole idea of if a cell tower were to go in eventually, it would be after the entire stormwater plan for the school. This includes significant stormwater basins and so forth, and there's none of that.
Okay.
That's my argument.
All right. I had kind of misconstrued your argument until this very moment, which is why we do closing arguments, because I thought you were against filling in wetland C. I didn't realize you were a wetland filling booster here, and there are more of it. Fill them all, says Miss Brown. All right. And the reason we want to do that is because filling in the wetland will prevent stormwater runoff. That part's not in the record that you have cited to me. So you've got a little weakness there. Okay. Anything further on wetlands and stormwater?
I think you've stated it very well. You finally pulled it out of me. Thank you.
I know it seems hellish, man, but like I actually am doing this to help you put on the strongest case that you possibly can. And the reason is, you know, I have to issue a ruling on everybody's arguments. And if I don't understand the arguments, then that makes it really hard for me to issue a ruling on the arguments. So that's the purpose of this little exercise. I think I said in my opening remarks, I'm not here to embarrass anybody or make this difficult, believe it or not. So, all right. I mean, the problem with this line of argument, ma'am, is, you know, yes, you're right. The staff report says they're going to fill in the entire wetland. And arguably, there may be a little strip of it right there next to the driveway that never gets filled in, right? So that's some kind of inconsistency. I grant you that. At least it's an inconsistency between a staff report and the ASDP, not necessarily between the MSP as a whole. But even if that's true, I don't see that makes that automatically makes a stormwater issue. Like, we don't have a drainage report, you know, where some hydrologist comes in and says the only way to stop stormwater problems is to fill the wetland. Like, we don't have that. We have your speculation that's, you know, that may be one of the many good reasons to fill in the wetland, but that's all it is your personal speculation, which is not evidence. The other problem I have is, you know, even if it's true that the failure to fill in wetland C, you know, will lead to stormwater problems, which is not at all in the record, at least not that you pointed me to, then we have to tie that back to the criteria of review for the ASDP. All right, let's say they screwed up the stormwater by not filling in the wetlands, and Mrs. Brown has proved it. Okay, let's say we were there, which we're not, but let's say we were. Where does it say in the code that that's grounds to reverse the ASDP? Because you know, as I read the approval criteria. Now I'm the one that doesn't have it up in front of me, but I don't recall that, you know, solid stormwater management was one of the criteria I'm supposed to review on this ASDP. I don't think it is one of the criteria, frankly.
However, it is in PRJ.
All right, direct me to where it is in the PRJ. This is Exhibit 33, the council decision.
Oh, there's, if I must, page 106 again in the staff report.
Staff report is not the PRJ decision, but okay. Page 106 on the staff report. This is Exhibit 15, page 106. Very well. and somewhere in here, I'll see a rule that says you can't cause stormwater plans, or you can't cause stormwater problems. Because what page 106 is actually talking about, ma'am, is the critical areas ordinance, which says wetlands have to be protected. And there's some discussion about why we don't have to protect this particular wetland. That's what's on page 106. Page 106 is not a stormwater finding. So if your argument is all this wetland fill or non-fill is going to lead to stormwater findings, you're going to need something other than page 106.
The planned groundwork is described in ASDP. There is extensive documentation in the PRJ 19 site plans and so forth for stormwater tanks and so forth to be installed in order to compensate for the fill-in of wetland C. That's all I can say.
Very well. What other issues do we have?
And I think that's pretty much it. Again, I believe I've made a good argument, and I know that you've really pushed me here to reveal some things, but I do believe, based on all the documentation I've given, that this ASDP 22 should either be vacated or remanded back to the city, and then the city can decide on amendments, or there's also, and I'm not allowed to bring this in, but the school may propose different arrangements, different buildings, which would entirely change this.
Okay. So one thing I didn't hear you talk about, ma'am, was one of your issues related to it's issue number 4, which says prior to issuance of the ASDP, the applicant must provide their access easement to use Providence Loop. I didn't hear any argument from you on that issue. What are you doing with issue 4?
That issue has been taken care of. I think you have made it clear that they have no access easement.
Okay, so you're just, I haven't made anything clear. I've asked a bunch of questions. You're the one that needs to make things clear.
I would reinforce what you have said.
I haven't said anything. I've asked questions of witnesses. You tell me what's going on with issue 4.
I would say that, as I say, to the applicant's knowledge, no access easement has been provided.
Okay, no access easement has been provided. Okay.
And they must do so as a condition. So they have not met that condition.
Very well. All right. Thank you, Ms. Brown. Any other argument on any other issue?
I don't believe so.
What am I to do with issue 7? You cited a bunch of weird land use decisions, AAS CNW and AAS 21 FAR. I didn't hear any witness testimony on any of that. I didn't hear you mention it in your closing just now. Are you dropping issue 7?
Oh, I'm not dropping any issue except what you've dropped.
Well, if you don't argue them, you're dropping them.
Oh, really?
Oh, yes.
Me. Okay. First, as I say, I'm going to use the second sentence. The proposed fiber conduit entails removal and excessive damage.
Wait. The second sentence of what?
Sorry. You have it now?
No, what are you reading?
I am reading issue 7 that you asked about.
Oh, all right. So this is from your own notice of appeal, which is not evidence, but we will look at it together if that's what you want us to do. Okay.
The second sentence in there.
I'm reading the sentences.
Do you want me to read it or? I'll let you-
Now, your argument where you say, and look, Mr. Examiner, right there in the record is something that proves I win.
No, I appreciate your, the fiber conduit entails removal and excessive damage to existing vegetation and significant trees in this area. This is the area of the native growth protection easement in condition 7 of the city council decision on the master site plan.
Okay. And I'll just tell you frankly, ma'am, I've seen no evidence that even a single tree is going to be removed, but
I did show photographs
you
of
did?
the existing, yes, in my opposition to the motion and in the brief. So there are, it's,
Okay, all right. Give me some exhibit numbers. Hate to do this to you, ma'am, but it's your case and your burden. So the burden's a heavy one. That's why it doesn't feel good to bear it. Give me
Yeah.
something on the record that shows me they're doing this stuff, and then you give me some argument that says, you know, they doing this stuff's illegal. That's really what I need from you.
well, okay, so you need the exhibit numbers with the appendix.
The reason we need exhibit numbers is because no witness testified about this. So your only hope for any evidence whatsoever on this point is going to be the exhibits.
Where are the exhibit numbers? Hold on, please. Now, this is the opposition to the appeal. It's part of the record.
I'm sorry, ma'am. The exhibits that I've admitted are numbers 1 through 47, with the exception of the 3 that we called out earlier that have not been admitted. Nothing else has been admitted as evidence. What have you got for me?
I have the opposition to the appeal, which
Let's
But
take a
it's not an exhibit. It is part of the record of this appeal. I assume you have it. because-
So I have your opposition to the motion. I don't see any photos attached to it. What is the date of your opposition? The February 16 one, right? Oh, the appendix to it. All right, so I see the appendix. And there's some like black and white scanned photos in here. They are not supported by any kind of declaration or anything like that. Ma'am, this is not evidence.
Well, I did provide evidence. This is a very treed, forested slope. What more can I say?
All right.
That's it. And it will require, I did take photos, I submitted them,
He hasn't.
and you have them. If you want to review them, it shows that it would be virtually impossible to put that trench in without tree removal and
All right.
without disturbance of the vegetation. And this is in a native growth protection easement.
All right.
So-
Point taken. And for the audio record, what I have is a February 16 opposition by Ms. Brown to the respondent's motion to dismiss. Attached to that opposition was an appendix. The appendix includes photos. There is no declaration supporting the photos. That is what I have. So very well. And it sounded like that was going to be the what Ms. Brown was relying on.
Yes,
Okay.
and
All right. Any further argument on any other issue, Ms. Brown?
No.
All right.
Yeah, I think that's about it.
All right. We can always have more land use. I got a bottomless appetite for this stuff, but I know it's not always the most fun thing. So I appreciate your stamina, Ms. Brown. I appreciate your patience with me and my millions of questions. They are designed to make your case as strong as it possibly can be. And I think you did a good job answering some of these questions and bolstering your case a little bit on some of these issues. Let us turn now to the city for their response.
Would the examiner allow us to take a 5-minute relief break?
Sure. Yeah, no, I know that went a little longer than you were maybe expecting, huh? You probably told everyone you'd be home on time today, huh? All right. Well, it's 2:52. Why don't we come back at 3 o'clock? We'll take 8 minutes.
Okay, thank you.
Yep.
Confirmed.
Thank you. All right. City, let's go ahead with your closing, please, Ms. Soto.
Thank you. So we're here today on an appeal of an ASDP for a wireless communications facility. And the burden of proof in this matter is on Ms. Brown. However, not until these closing arguments did we even hear her reference the criteria applicable to a wireless communications facility found in former IMC Chapter 18.22. Instead, she focused primarily on issues completely unrelated to the school project or issues related to this alleged non-disclosure of information. It's pretty clear that the appellant and the neighbors feel that they were not aware of this instant cell tower project, but as the evidence is shown, and is shown in the site plans and the other documents as part of the record here, the project was contemplated in the MSD and SDP approvals for the ISD project.
At that time, was it contemplated as a temporary or permanent fixture?
I don't have the answer to that. I cannot testify on behalf of the city regarding that. But as you could see in the documentation, it talks about a proposed cell phone tower. It also talked about potential permanent facilities being noted in the staff report.
Okay. And frankly, even if it was, didn't appear on the site plans or in the staff report, that doesn't mean cell phone towers are permanently blocked for all time, does it?
No, it does not mean that.
All right.
So, the hearing examiners asked the parties to address certain issues in our closing arguments, but that should really not be a substitute for Ms. Brown's failure to provide evidence and testimony to support her case. It's really placed part of the burden back on the city and the applicant to disprove her case. And it has not afforded us the ability to cross-examine her. She was essentially testifying during the last hour, or put on any other rebuttal witnesses on those particular issues.
I'm going to stop you there, Ms. Soto. She was not testifying during the last hour because every time she would, say some factual thing, I would, demand that she would cite it in the record. Then she would kind of painstakingly go through the record to try to do that. In some instances, she was able to find something. In other instances, she was not. So I think that's a little bit unfair to say that she was testifying. She was forced by me to rely on the same documents that you've had all along. So you ought to be able to use those same documents to rebut her, I would think.
Correct, but as I was explaining, we did not get an opportunity to cross-examine anyone on those issues, and it is her burden.
Well,
so she needed to present her case.
The opening briefs are optional. Opening statements are optional. If she and calling witnesses is optional. If she wanted to, she could have called no witnesses, provided you, nothing, and then just come in on closing arguments and started citing documents. So, just procedurally, she did nothing wrong by springing these arguments on you.
So we haven't heard any evidence or testimony that concerns actual inconsistencies between the MSP and the SDP and the ASDP at issue in this appeal with respect to the criteria that is looked at for an ASDP. Regardless of that, however, as Mr. Getz testified, these approvals for the ISD project were conceptual. All of those details are worked out in the construction phases of the project as acknowledged in the decision. They're also contemplated through condition number 5 in Exhibit 33. That is the actual decision. So, but to the extent that the hearing examiner determines that there is an inconsistency between the MSP and SDP and the ASDP, that is relevant to the criteria for approval, then the city would simply request that the hearing examiner condition that ASDP or remand back to the city to require a condition for compliance with the MSP and SDP, or require an amendment if necessary, if there was actually an inconsistency. However, the city's position is that there are no inconsistencies that matter for this particular matter.
Yeah, I think I'm with you on there. And I kept asking her, where's the inconsistencies? Where's the inconsistencies? She eventually came out with condition 7 of Exhibit 33. But, you know, and this is in your briefing, Ms. Soto, the NGPE is not even required to exist at all until the building permit phase, which we are not at. You know, and plus you've got kind of the carve out of the square that's been there, you know, all along. So you know, even if they had to do an NGP right now, that the NGPE would still have the little square carved out because that's been on the site plans. So I do not perceive an inconsistency between the master site plan and the ASDP that's under appeal. I do potentially perceive an inconsistency between the ASDP and condition number 1 of the variance, the height variance for the tower, which says prior to the ASDP, you've got to get an access easement. So I'm hoping that you'll, you know, give me some argument on that.
I will address that. I would like to go through the remaining issues in order. And so next I'll start with issue
inconsistency. I don't think I need more argument on that.
Thank you.
So if we're doing them in order, maybe you can give me something on issue 2, wetlands and stormwater.
Sure. So the city's position is that Ms. Brown has wholly failed to address the stormwater and wetland issues. The the comments during the closing argument and these passing references simply were not enough to overcome the burden. First of all, stormwater and the wetland fill is not something that is even considered as part of the ASDP criteria. So right there, it is not relevant to this case. Regardless of that, however, the evidence shows that these things were addressed in the MSP and the SDP approvals. Wetland C was approved to be filled, and mitigation has already been addressed through payment into the Wetland Mitigation Bank. Those are found, the evidence for that is found at Exhibits 10 and Exhibit 39. Yeah. And the stormwater items are simply not something that would be considered as part of this type of permit. Those are things that are addressed later as part of construction permits. And that is explained in the city's pre-hearing brief. We did not have testimony on it today because it was not clear whether Ms. Brown was going to even raise these issues. So yeah, the city's position
was, you know, something in the site plan shows stormwater tanks, you know, and therefore, you know, you've screwed up the wetlands. That was basically the argument there. So, all right, I don't need more on wetlands and stormwater, I think.
So next is issue number 4. That is the access issue.
Yeah.
So the city acknowledges that there was the condition number 1 in the variance decision, which is Exhibit 7 of core document number 1. And in approving the instant ASDP, the city staff had initially determined that that condition had been met. However, on further review, and as you've heard in the testimony today from Mr. Yormick and from Ms. Taylor, the city has now reviewed that temporary license agreement between ISD and the applicant after the fact. And although that agreement has expired, it did provide access to that lease area as of the date of approval of the ASDP. I understand.
Approved as of the date of the ASDP by its own terms, it says you're only getting this for a temporary facility, yet the ASDP is for a permanent facility. So how is access for a temporary facility the same thing as access for a permanent facility?
Right, and I understand the hearing examiner's concern. And so to the extent that you know, the hearing examiner finds that that is not sufficient, the city would ask again that either a condition be placed on this or it be remanded on this particular issue so that this this thing, the access issue could be resolved.
So what would that remand look like? It would say remanded, on appeal issue 4, variance condition 1 said you had to get an access easement before the permit came out. So remanded for you to go get your access easement, once you have it, then what? That it's a new like appealable decision for Ms. Brown to deal with, or like what procedurally, how does that work?
That's a great question.
Maybe I retain jurisdiction, and once
I
you
think
get
that
access
would be
easement,
appropriate.
we just continue the hearing. Is that it?
I don't know if we would continue the hearing.
Yeah, because you'd have the easement. The problem would be solved unless Miss Brown finds another problem with your easement. So procedurally, what does that look like? I remand to you. And do I retain jurisdiction or not? I guess that's kind of what I would be thinking. I think the answer is yes, because Miss Brown said you don't have an easement. I would remand for you to get the easement. Then we would reconvene and we would say, all right, there's the easement. Is it an easement or is it not? Right. That's what that would look like.
An easement, or also it could be alternate access.
Yeah. Right. Yeah. Yeah.
I suppose that would be a way that we could handle it, particularly given that any other issues that got dismissed wouldn't be able to be brought up again as part of that. It would be limited just to that particular issue.
Yeah. So it wouldn't be like a new appealable land use decision, because, she'd probably find a bunch more issues to snipe at you with, which I assume you don't want. So you would want a narrow remand with retention of jurisdiction by the hearing examiner in the event I find that you don't have an access easement already, right?
I think that could work.
Okay, all right. But give me some more argument on why you do already have an access easement, or were you finished on that point?
I will defer to the applicant on that particular issue.
Fair enough.
Next, regarding issue.
Maybe address the one thing. This took a long time to pull out of Ms. Brown, but one of the objections that she has is not just that the easement is only for a temporary facility. The easement connects to, what's the name of the darn road? The Southern Road is how I think of it in my own.
The Loop Road? Yeah,
the Loop Road. And then that connects to 228th. And then Ms. Brown has found this finding in the staff report, I think it was at page 152 of Exhibit 15, that says, the connection between the Loop Road and 228th will be for emergency vehicles only. And then she argued, your cell phone vehicles aren't emergency vehicles, so even if they have an easement that gets them from the tower to the Loop Road, they still can't go from the Loop Road to 228th. That's how I eventually understood her argument. What response do you have to that?
I can deal with that if you like. I know I'm interrupting.
Very good. All right. So it's nice to have friends there, Ms. Soto. Ms. Brown didn't have that that second line of defense. Okay. All right. Now we can move on to a new issue.
I will defer to the applicant's counsel on that. Regarding issue number 5, the tree removal issue. Again, the city's position is that Ms. Brown has not met her burden. As the hearing examiner has pointed out on a couple of occasions now, the condition regarding the NGPE only provides that an NGPE will be recorded in the future. That is not something that is currently in place. Right now, all we have are documents that show an approximate vegetated buffer. And we have a tree retention plan that already shows trees being removed from trees being proposed to be potentially removed from the area that was marked as the approximate buffer in the documentation. So
that's right. Exhibit 36.
What was that?
Yeah, you're talking about Exhibit 36, trees that are potentially to be removed. That's documented in Exhibit 36.
Correct.
All right, let's take a gander at that. Because Ms. Brown probably wouldn't agree, but I think I'm doing her some favors in with her case here. I don't actually like this exhibit. There was one that showed existing trees inside the square, and I wanted to ask you about this, and I had it all teed up, but then we started looking at other things. Shoot. Oh, I remember where it was. It was in exhibit.
I can pull up one of the documents that
Yeah,
shows this particular area.
Well, so let me pull up this one particular document for you, or maybe you can you do the exhibit 2 plan set? That's exhibit 2 to exhibit 1. This is the plan set for the ASDP, not the plan set for the MSP.
I got it.
Okay, and can you do this? Well, maybe we don't have to do a screen share. If you go to page 4 of that,
Yep.
I see the square. The proposed tower location says there's some trees in there. I count, 1, 2, 3, 4, 5, 6, 7, 8, 9, about 9 trees thereabouts inside that square. Yeah.
Yes.
Okay. And if we go down to page 8, which shows what's proposed there, there's the giant tower right in the middle, and then a bunch of equipment lease areas, and a bunch of other, technical terms related to equipment. But it looks to me like, when you start off on page 4, there's 9 trees there, and by the time you get down to page 8, the proposed build out, there's no more trees. They're cutting down trees, right?
I mean, that's not specifically what this shows. It just shows that there are not trees in that area.
Well, but it also shows that, it's an equipment lease area, right? I mean, the equipment's not going to be mounted to the trees, is it?
Can we look instead at page 13 of that plan set?
All right, page 13, I'm there.
Can you bring this?
Oh, better yet, existing tree to be removed. Look, I was right. You were so reluctant to go there with me. But look, 1, 2, 3, 4, 5, 6, 7, 8, 9. I even got the number right. Chopping down 9 trees. Right, that's the one with the red X's?
Yes.
Okay, so they're chopping down 9 trees. When I go to the approval criteria, 18.22.100, B1B, preserve existing on-site vegetation and minimize disturbance of the existing topography, unless such disturbance would result in less visual impact of the site to the surrounding area. Chopping down 9 trees. How is that consistent with the requirement to preserve existing on-site vegetation?
Well, I mean, it does not say that trees cannot be removed.
What?
They're still
Wait, you chop them down, but you're still preserving?
I mean, Mr. Examiner, you're asking me to answer questions that are actually better addressed by city staff. And
Well,
again, the
I'm
city's
asking you as a lawyer.
position.
Wait. I'm asking you as a lawyer. Rule, preserve existing vegetation. Facts, chopping down 9 trees. Argument? That's what I want to hear.
The city's position would be that if they're applying for a permit where this is the only place where it can go, they've just determined that this is the best that they can do for preserving the trees. It doesn't say you cannot take out any trees. It does not say that all vegetation has to remain.
What does preserve on-site? What does preserve existing on-site vegetation mean? What do those words mean?
I'm pulling up the code. Just one moment.
It was 18.22.100. And then the subsection was B1B.
I think if you look at the next section, B1C,
Okay.
it talks about.
I'm just going to check. Be designed and placed on the site in a manner that takes the maximum advantage of existing trees, mature vegetation, and structures, as to use existing site features to screen as much of the total facility as possible, and or use existing site features as background so that the facility blends into the background with increased site distances. Okay, so C is a requirement. B is also a requirement. How do we meet either of those requirements here?
I think when you read these two provisions in conjunction with each other, it is still designed in a way that is taking maximum advantage of the existing trees. Not all of the trees in this.
How does chopping them down take maximum advantage of the existing trees? I don't understand.
Your Honor, I can help address this during.
Well,
our
you'll get your,
closing
turn, but I do want to hear the city's take on this. Issue 5 and 6 were all about tree removal. I grant you that, she did not spell out the argument, very clearly, but the issue was raised. She says you're chopping down trees and when you're not supposed to. I have a rule here in B that says preserve existing on-site vegetation. There's 9 trees coming out. I just want to know, are we consistent with that rule or are we not? And if we're not consistent with the rule, you can just say so. I mean, it doesn't have to be,
I think it might be helpful to look at the approval that the city, or the criteria that the city reviewed,
What do you
and
mean?
the actual decision on the ASDP.
Aren't these the criteria though? Like 1822?
Right, but review it in conjunction with the staff's analysis. Rather than have me provide that analysis, I would rather turn to the staff's analysis on that topic.
All right, well, let's take a look. We've got Exhibit 1. Let's take a look. What did staff have to say?
So the staff's response in the ASDP is that existing trees will be preserved to the maximum extent feasible to screen the facility.
Where are you looking?
I'm looking at page 4 of core document 1.
Okay, page 4 of 5, and we are looking at, okay, so I see B1B, staff response. Okay, the existing trees will be preserved to the maximum extent feasible to screen the facility. Additionally, landscaping is proposed around the equipment enclosure to provide a visual buffer. Tree replacement for tree removal is proposed. Okay, and your argument, Ms. Soto?
So staff analyzed that particular section and determined that these trees would need to come out, but they were preserving the trees to the maximum extent feasible.
Okay. How do you square that with the plain text of B1B, preserve existing on-site vegetation? I'm just looking for some argument on that. I've got staff's analysis. Now I need to square that with the actual rule. And I'm hoping you'll do that squaring for me.
Again, the city's position is that they analyzed the criteria that's in the code. They looked at what's required as part of the MSP and SDP. They looked at the tree retention plan and determined that they were preserving the trees to the extent possible for this particular facility.
So when you read, requirement B1B, which I will be applying in my decision, and where it says preserve existing on-site vegetation, you read that to say preserve existing on-site vegetation to the maximum extent feasible. That's how you read that, even though those words aren't there.
I read it to say preserve existing on-site vegetation, but not preserve all existing on-site vegetation.
Okay, so as long as
It
they
does
preserve
not
a little bit of
say,
vegetation, that's good enough.
well, they're preserving other vegetation. It doesn't specifically call out trees. They're preserving other vegetation on the site.
Okay. All right. Any further argument on this, which I'm this is issues 5 and 6 kind of lumped together. Anything further on this?
No, nothing else on this.
Very well.
The city would actually say that there was no testimony regarding, or no evidence presented regarding issue number 6.
Well, what was issue numbers? In my mind, issues 5 and 6 are all just trees. Issue 6 is maintenance of trees and landscaping. Yeah, I'm with you. We heard nothing on that. All right.
And then the last issue is issue number 7. Again, we didn't hear any evidence or testimony today regarding the placement of conduit, aside from the comments during Ms. Brown's closing statements. As discussed in the city's pre-hearing brief. However, these are issues that are typically addressed during the construction phase. She hasn't identified any actual inconsistency regarding the placement of the conduit between the MSP, the SDP, and the ASDP, nor has she pointed to any criteria for approval in 18.22 regarding placement of conduit. So again, the city would ask that this issue be dismissed.
Yeah. All right. Well, I'm not going to dismiss issues at this point. At this point, I'm just going to hand down a decision. But yes, I understand what you're asking. Okay. All right, Ms. Soto, did you have any other thoughts on anything else that we've heard during this hearing?
I have nothing further.
Very good. Thank you so much. Mr. Bush, your turn now.
Great, thank you. In addition to what the city has argued, I'd like to have a discussion with you about the remaining three issues. The easement question, South Loop Road at the intersection of Providence Point, the main road, and then the trees around the site plan.
Okay.
So the easement question, the condition in the ASD, in the variance, called for, in my mind, a one and done. All you have to do before the permit is pulled, there has to be some demonstration of the right to use the property. The word used there was easement or other arrangement. And there were two easement, or the two rights that the carriers had on the property at the time the variant, the ASDP was issued. The first was that 1979 easement. And as you correctly pointed out.
Wait. You mean the 97 easement?
97, my apologies.
Okay, all right. Yeah.
And the 97.
I picked up some notes earlier too. Yeah, so yeah, just
well, I'm just seeing if you're paying attention. So
yeah.
You are. That's good.
All right.
Okay. So the 97 easement, and you are correct, there is a 4-foot gap, plus or minus, between the dotted line of the 97 easement as it goes down to the southern portion of Loop Road, and the drawing in the easement exhibit, the license agreement exhibit, where you have the 60 by 60 parcel, and then the access that comes over to what's stopped at the future road. You know, that the road that comes down from the bus turnaround. The parties contemplated first the license did not try to take more than was necessary, given the planned development of the property. So that driveway access to the 60 by 60 parcel was only intended to connect the dots between the parcel, you know, the access drive, and the proposed future common access driveway. So rather than encumber the common access driveway, the license stopped at the border of that. And eventually the parties would rely upon the common access driveway as their path of access.
And that comes in from north, right?
That's correct.
Yeah.
And one of the reasons why we introduced the temporary license is to assure the community that we plan to come in from the north using the other access right negotiation for the new agreement as well as the existing agreement. So we do plan to come in from the north. But if things get remanded, we don't know what kind of decisions or testimony would come in. So we'll talk about that in a minute.
Okay.
So what we have in the record today is connecting the three parcels, the pieces. It's the easement that existed since 1920, I'm kidding, 1997. The driveway from the 60 by 60 that was in the license agreement, and then utilizing what the school district anticipated. And because it was put on the documents, we believe we can use that. But I fully understand if you question that and you follow the city's recommendation that there's a remand.
Yeah, a license is not an easement, yet it has an expiration, which we are now past. As a matter of fact, from Ms. Taylor, it's not even in effect today, and yet you still want to have to uphold your thing. I grant that I'm supposed to look at the events at the time they occurred. I'm not supposed to, I'm not a time traveler. I'm not allowed to go back and reverse the city based on what I know, from the future. I understand all that, but even at the time, it was only ever a temporary license and not an easement. And the difference between those, now putting on my time traveler hat, are all too clear because temporary licenses expire, and sometimes negotiations for permanent access take longer than you might wish. So And frankly, I'll just even note, you don't know that you're going to get permanent access from the school at all, right? Like they have an obligation to negotiate in good faith, but the school district can't guarantee that you'll ever get your access. I mean, who even knows what kind of considerations could come up for them? So it is kind of
Well,
speculative,
I'm
that you have
going to
access.
correct you. I mean, we're not really talking about permanent easement here. Okay, because the wireless, I've been in the wireless industry in Issaquah since 1986.
No, it's a lease area, not a, yeah, all right.
Yeah, you have a lease area, then you have access rights. Sometimes it's a documented easement, but the leases are X number of years, and they're not intended to be permanent like a roadway.
Right, yeah, I get you, yep.
So the parties generally, if you're going to say, where's the easement? Well, the parties generally don't necessarily get an easement.
Yeah.
You get some type of access rights, and because it's called a license, it's terminable, but it's in a contract, and there's
the lease
rights and obligations.
We don't freak out about that.
Exactly. Well, we freak about everything. That's what we're doing. But, so really, what we're talking about is at the time, and my position is at the time the ASDP was issued, was there a right that moment in time to access the property? And we had those three pieces: the 97 easement, the road identification by the school district, and the connecting license driveway. Okay, that's what we have, and we think that's sufficient because it's a moment.
I would be happier if the let's say the ASDP had only approved your site plan for 2 years or whatever the term of the driveway connections. Then I would say yes, there's a match between the length that you have driveway access and the length that you have your cell tower.
Yeah.
But here where the driveway is approved for 2 years or whatever that was, and the cell tower is approved for, I don't know, some what is the term of that lease anyways, longer than 2 years in any event, there is a disconnect.
Sure. God, I have a thought that just escaped me. That's not fair.
What, I'm not fair? I'm not fair to anyone.
No. Oh no, that's not. Just give me a moment to collect my thoughts.
Okay. Yeah.
The reason why this is unusual, and it's a curveball for everybody, and I just got my thoughts. So thanks for the opportunity to collect the thoughts. The question about access never comes up at this phase. And the only reason why it's here is it was found, is because of all of the testimony about it. The time that the occupant needs to prove access is when you come in for your site development work permit. And we submitted in as one of the exhibits. I can get you the number if you need it. But when you take a look at the City of Issaquah's site work permit application form, you have to prove access. And when it's a conceptual land use approval, we're not required to prove access. If we had been required to prove access, we would have come in with all of that information.
Beefed it up a little bit more, right? It wouldn't be coming in as your rebuttal exhibit, like a
exactly
hearing or whatever. Yeah.
Okay. So the safety valve here is if you approve it with a condition, get the access, or if you approve it straight up, or even if you remand, there's still a safety gap, and that is the 100% always enforced site work permit. You have to prove that you have access. And so this is the unusual part, is that it shows up here.
No, I agree. And the reason I was talking with Ms. Soto about remand is, she brought it up as a possible remedy if I found a violation. But, the hearing examiner can approve, reverse, remand, or modify. So with Ms. Soto, we were exploring what would a remand look like. Let's you and I explore, Mr. Bush, what would a modification look like? What would a modification to the, 9 conditions of approval of the ASDP, what would it look like, to guarantee access as the variance decision says we must? What exactly would that language look like?
Well, frankly, to mirror, in my mind, what's going on with the site work permit application, again, assuming I'm using the right phrase, I've got the permit here in my desk scattered around somewhere.
Yeah, I don't know either.
You need to bring in, proof of lawful access to the public right of way, either by easement, license, or other agreement, prior to the time of applying for the site work permit, but that's what's already required. So if you want to connect the dots between the variance, the ASDP, and the next steps, that would be the way to do it. Is to require proof of access, lawful access from the public right away at the time, but prior to the time you apply for a site work permit.
Prior to which they would have to do anyway, so it's kind of a meaningless condition even to write in there.
Right, but if we don't comply with it, we can't proceed.
Yeah. But that would be true regardless of whether I wrote a condition in there, is what I'm saying.
That's
I would basically be doing this to kind of check the box on that variance condition number 1.
Yeah, but you'd be matching, you'd be consistent with the city's existing process.
Yeah.
And I think there's value in that.
Yeah, I agree. And, frankly, if the applicant's concerns about access are correct, it's a bit of a poison pill for you, right? Like if for whatever reason, because of like the spacing between arterials or whatever, you can't get your access approved, then you're never building anything anyways, are you?
Point 2, let's go to Loop Road.
All right, talk to me.
All right, so 2 options there. 3 options. Number 1 is we're in negotiations with the school district, and the negotiations are taking a long time for whatever reason, but we're getting close to the conclusion, and it includes access. So that's not in the evidence, out of the record.
No, it's not. Yeah, no.
But it's fine.
I mean, we had Ms. Taylor's testimony on it, but even that is speculative. She cannot guarantee that the school district will ever give you access.
Exactly.
So that was in the record. It's not very persuasive.
Well, but if we don't get a lease, we can't build it.
Yeah, that's true. Yeah, a lot of ways this could go wrong. Okay.
Yeah, exactly. So, and this is not unusual in the industry. The pieces come together as you move your way forward. And it's that way all the time in development, just like what the school districts are going through. You take it one step at a time.
Okay.
And that gets to one of my last points. But when you take a look at that deviation that we talked about, read the words carefully, and I highlighted it here.
So I'm going to exhibit 15, page, whatever it was, 152.
153, 152, 153. It's 153 at the bottom of the page.
Wait. All right, 153.
Okay.
So this was the basis for Ms. Brown's argument that, whether you have an easement or not, it's basically not usable. All right, 153, I'm there.
Oh, okay. What it actually says at the left margin where it says approximately 1,200 feet, the next sentence says, the standard allows for spacing less than a minimum if access is limited to right in, right out.
Right.
Which means if you're southbound on 228,
yep,
you can turn right in.
Yep.
And then when you exit, you can turn right out. We can walk in and get that permit tomorrow.
And continue southbound on 228. Yes, I agree.
Exactly. Okay. So that's one option. If we are unable to work out access through the bus parking area and the fire emergency, then we can open up a right-in, right-out access to the property.
And get your easement off the 1997 easement.
Exactly.
You still that little segment, the connector. Yeah. All right. Well, so this is all speculative, but okay, I'm with you. What do you make of the sentence after that, though, sir, which says the existing access will be converted to emergency vehicles only with full access during emergencies, and a deviation is required? Isn't that a commitment to the city to keep your vehicles out, ambulances and cops only? You're not an emergency vehicle.
That is correct. That goes to left in, left out. So when it says full access, the existing access will be converted to emergency vehicles only with full access, which is left in, left out, right in, right out.
The existing access will be converted to emergency vehicles only with full access during emergencies.
Right. Okay.
It's not super well worded. What am I reading here?
Well,
I think what you think this is saying is right in, right out is for everybody, including the cell phone vehicles. But during an emergency, the emergency vehicles can do whatever they have to, any kind of turn they need. Is that how you are reading this language that we're discussing?
I agree with you. It's not written so well. I think ultimately they intend to make it emergency access only.
Well, that frees
and if somebody, yeah, it does. But if we come back in as a part of the remand and ask to reopen this, that is a part of the modification to the master site plan that is another option to the 3 or 4 different options that we're discussing.
So if somehow the result of this ASDP process was you have to use the easement and record a new easement for the connector or whatever, whatever thing it was, and that forced you onto that road and it was emergency access only, then you would come back for a minor amendment to this MSP saying, in addition to the emergency vehicles, make sure cell phone vehicles can get in there too.
Right in, right out.
Yeah, but that gets me to something that I was hoping that the parties would address in their closings, which was in terms of consistency with the MSP, don't we have to, if you don't like what the MSP says now, don't you have to change it first and then do the ASDP? Because the MSP is supposed to drive the ASDP. It's not supposed to be the other way around. The ASDP is not supposed to be driving the MSP. So I don't think it's quite right under 1804 520 to get an ASDP that says something and then retroactively correct the MSP to authorize that thing.
Well, I apologize for not remembering Chris's last name, the former Issaquah employee. Yes, thank you. Mr. Getz did talk about it just briefly, though. He said you can use a condition. Same thing that we're talking about here. Yes, we can approve this, on the condition that you go back and get an amendment. You still can't proceed.
With conditional approval, conditional on the amendment to the MSP, something like that.
Exactly. And frankly, it happens all the time. Because at the end of the day, regardless of whether you flip heads or tails, you still have to get all of these approvals before you can pull permits.
Right.
So really, it boils down to a procedural question. Again, if you approve it with a condition, if you remand it, retaining jurisdiction, the end result is the same.
Yep.
It's just what's the process?
Yeah, that's exactly right.
Do you want to be consistent with the city code and how it handles permits, or do you want to create a separate process that's different from that, where it comes back to you by design?
Yep. All right. Well, what I don't hear you arguing, at least not very strongly, is that, well, no, never mind. I won't put words in your mouth. I think I understand your arguments.
Oh, go ahead. I'm ready for you.
No, I've tortured everybody enough. Okay, so that was for access. And the intersection, which is obviously related to the access. You said you were going to give me something on trees also?
Trees, okay. Let's go back to the tree removal plan.
Okay, so that was
I'm not there.
2 of Exhibit 1, page 13, the one with the red X's. 9 trees coming down and a requirement to preserve existing vegetation. You were going to be left with the hot potato to explain how chopping down all 9 trees preserves the vegetation.
Okay, there's 3 or 4 different prongs to it. Don't let me forget to cover all 3 or 4.
Okay.
All right, number 1
for this hot potato, huh?
I'm wearing gloves now. All right, number 1, you have to have a reasonable interpretation of the code, because if there is a strict reading of the code, no one could ever build anything. Period.
Yes. Even a blade is vegetation, right?
Exactly. You're in Issaquah. There's going to be trees, and wireless communication sites that accommodate 4 carriers are going to be 60 by 60. There is nowhere anywhere in the state of Washington where you can build something like that without disturbing some type of vegetation.
So that's not in the record, but rhetorically, I take your point. Yes.
Yeah, well, it's rhetorical, and I'm not going to come on.
Yeah.
So you get it. So you have to have a reasonable interpretation of it. Otherwise, under federal law, it's an effective prohibition. We don't need to go there. It's federal law. Telecommunications Act of 1996, local jurisdictions can reserve jurisdiction over zoning.
I do a lot of
unless it's an effective prohibition.
I know all about the federal rule there that we can't just exclude them from Issaquah.
Okay, so if we interpreted this to mean you cannot cut down a single tree, then effective prohibition, we're done. So that's why I think you need to have a
single tree. You're chopping down every tree inside your area. All 9 of them.
It's how do you interpret? First argument is how do you interpret the code? Has to be reasonable.
Okay.
Well, second argument.
Wait. So I agree with you. A code interpretation has to be a reasonable one. I'm certainly not going to adopt an unreasonable code interpretation. What is the reasonable interpretation of preserve existing vegetation? Could you let me flip it around on you? let's say we level everything on that site, but we preserve one blade of grass. Blade of grass is vegetation. We preserved it. What is the reasonable interpretation here?
Okay, so you hit on one thing, and that was my second point, is what's the site?
Okay.
Okay. As the code is written, site throughout the code doesn't refer to 60 by 60. Site refers to the property. Because the next section the next section you read, the next section that somebody read when we talked about site, and I think it was Anne Marie, site referred to the entire property.
All right, citation. Give me a citation on this, because I mean, the name of your permit is literally an administrative site develop ASD, an administrative site development permit. You have a permit to develop a site, and it is a 60 by 60 site. So now you're going to say that your site is actually larger than the bounds of the permit application you submitted. I mean, like I said, I want to see some citation on this if this is what you're going to hang your hat on.
One section down, B1C, let me read it.
B1C, okay.
Be designed and placed on the site in a manner that takes the maximum advantage of existing trees, mature vegetation, and structures, as to use existing site features to screen as much of the total facility as possible. If that standard was applied to 60 by 60, it's meaningless.
Why?
Because if you're going to put in a cell tower with the ground equipment, that 60 by 60 will have nothing left to be a building that'll screen, to be I'm trying to look at the rest of the words.
Well, no, it just says
there won't. It's just no.
The
language
so,
there refers to the property.
Well, so it says, you know, your facility has to be designed and placed on the site in a manner that takes the maximum advantage of existing trees, vegetation, and structures, as to use the existing site features to screen. This is just telling you that you have to use whatever's there as best you can to screen your facility. I don't see a basis here for you to make the argument that I think you're making, which is the site for our cell phone tower is this enormous high school campus, and there's plenty of trees on that thing. How does Section C support that argument, if that is the argument?
Because it refers to the background. It refers to the area surrounding the site. The whole section, in order to have any meeting,
right? The area surrounding the site. Yeah, the high school is the area surrounding the site.
But existing site features, such in the fourth line of B1C, existing site features as a background. There's no background to an existing site if it doesn't include the entire property. The standard takes into and we're not going to say that the entire, I can't remember how many acres it is. It needs to be evaluated. It's the area surrounding the site, including the background. That's the view from the adjoining properties, from the right of way.
Oh, I see. All right. So here's maybe a better way of making that same argument. You tell me if you like this or not. B1B says preserve, but it says existing on-site vegetation. It doesn't just say vegetation in the neighborhood. It says on the site itself.
Okay. Three definitions of site, on site. Number one is 60 by 60. Yeah. Okay. I don't think that's reasonable. Number two is on the high school property, because this just happens to be a large piece of property. Typically, we don't get these located on such large parcels.
Right.
Typically, they're on less than an acre, plus or minus whatever the situation is.
Right.
So again, a reasonable interpretation of the code is such that whatever the impact is to the surrounding community from the direction of view, screening trees, access from the right of way, and so on, all of that comes into play. And it's just meaningless to say you're limited to analyzing 60 by 60. You have to take into context of surround the rest of the property.
Well, and I will just note, here in the record, Exhibit 3 to core document 1, which is the notice of application. And this is the notice of application for the ASDP. It says size of subject area in acres, 28.86, 1.2 million square feet. That's the notice that the public received for what the subject area would be. So that maybe lends some support to your notion that the site here is not 60 by 60, but rather the entire parcel, which in this case is humongous.
Yes.
Interesting. I wonder, do we have a definition in the code of the word site here in 18.22? Am I going to find a code definition? Because you know, if this is a big record, and if we cherry pick it hard enough, we can probably find something that supports any position.
You have 13 hits.
Yeah, and bear in mind too, we're going to have to use the old definition, but 18.22.040 does seem to have some definitions. Unfortunately,
sorry.
It doesn't have definitions of the site. Oh, well. Yeah, so your site is the high school, but your development permit is only for a little portion of the high school. All right, this argument is not quite as bad as I thought when you first brought it up. I was kind of rolling my eyes a bit, but you've maybe persuaded me that there's something there. All right, did you have more for me?
I hope I persuaded you there's something more than something there.
Well, these are new thoughts, and I have to kind of digest them for a while.
Okay.
And we're going to give Ms. Brown a rebuttal as well. Did you have more for me on trees, Mr. Bush?
Yes, I did. I wanted to go back to the actual XXXX.
Oh, the red X's. Okay, yep.
Page 13. Yeah.
Page 13. I'm with you.
And I don't know that we need to bring it up on the screen. It may be helpful. I'm sorry. I don't have the ability to do that real quick.
I can do that.
I was just going to say, is Magic Doug still on the line?
He's there. Yep. All right. Let's see the red X's, Doug. This is Exhibit 2 of core documents number 1. It's the plan set for the ASDP, and then PDF 13. You got it. Good. All right.
Coming up.
Perfect.
Red X's.
Thank you, Doug.
You're welcome.
Okay. When you read the master site development plan for the school district, the X's inside of the 60 by 60 are already designated to be removed, and mitigation is part of the mitigation that the school district is going to do site-wide, property-wide.
All right, so this is the site plan for the ASDP. If you're going to say
Correct.
that these trees have already been, slated for death and mitigation approved, I'll need some citation in the record to something from the MSP on that point. What have you got?
Can do. Let me do that second if you don't mind.
All right.
I will not forget about you.
Yeah, I know.
Okay.
This is your argument.
You won't let that happen anyway. So the 4 X's outside of the 60 by 60 are in addition to the 5 that are within the 60 by 60 covered by the school district.
I don't see the X's. What are you talking about? The 4 black X's that are closest to
the 4, I'm sorry. The 4 red X's to the lower left of the screen.
Yes.
The 4, they're outside of the 60 by 60 square, but inside of the dash.
Yeah.
Okay.
What's the dash?
That's just a zoomed in. You can see a larger image of this.
Oh, I see. On the next page. Yep, I got you. Okay.
Yeah. Okay. So those 4 are slated to be removed because of concerns over the potential of disturbing their roots.
All right.
So they can be left.
It's not in the record either, but you know this from somewhere that is in the record? I was beating up this.
There's a tree. I get. That's a fair question. I'm thinking about the tree mitigation plan. There is a sheet here that says tree mitigation, and Jennifer, I know you're in the next office over. If you can slip me a note on the tree mitigation page in the deck, that would be great. And she's probably going to come in and hit me for doing that to her.
Well,
but those 4 are The total is included in the tree mitigation plan, and I'm gonna,
And when you say the tree mitigation plan, like I know what that is some kind of plan associated with the MSP?
no, it's a part of the ASDP plan set.
Oh,
So
all
I'm
right.
going there now.
But we're in the plan set, the 102-page plan set. The red X's themselves are part of that.
But
all right, so somewhere in this exhibit that we are already looking at, you'll
one page down, page 14.
Page 14, okay.
Thank you.
Yeah.
Okay. Is the tree replacement landscape plan tree replacement 9-to-1 for anything that's removed in addition to what is covered by the school district? I think it's 9-to-1 for all trees that we're touching, even though 5 of them are already covered by the school district's site plan.
All right, which someone is going to find me in the record.
We'll work on that, Ned. And I know Jennifer's listening, so
okay,
if she has a chance to it's going to be in the school district's plan set that shows the tree removal plan.
Yep.
For the school district, and hopefully Jennifer can find that for us real quick.
Okay.
Right, the final thing is, and this is the 4. All of these tree removal decisions are one of those. It's too soon. These questions are decided when the site work plan, the site development plan is applied for, and you have a detailed tree removal and replacement plan.
Well, I was afraid someone was going to kind of go there because, in these multi-phase arguments, things always end up slipping through the cracks, right? Like either it's something that was already decided at the MSP phase, or else it will be decided at the building permit phase, and somehow it's never the right time to make the decision at this phase. And I don't know if I agree with that just based on 18.22.100, because I'm pretty sure that 18.22.100, applies now at the current phase, right?
Need to find it with you. I'm sorry. And I have it in a different screen. That's my
No,
problem.
I know it's horrible. Yeah, I'm constantly switching. That's why it looks like I'm never looking at you, because I have to pull up all these exhibits and citations.
Okay. Here we go. It's on my network.
All right.
18.22.100. Sorry about that.
Yeah. And then as B1B is this rule that we're arguing about: preserve existing on-site vegetation. I think that applies at the site development permit approval phase, right?
And I think you're looking at it on Doug's screen.
Isn't it one of the criteria? Okay.
It is, but we've included it in our plan set, and the city has approved it. Following traditional tree mitigation, your tree removal and replacement mitigation strategies.
Okay.
Now it's in the mice type, so I apologize. I'm going to go to my screen and blow it up as big as I can to see if I can find words that are helpful, because I know you're going to ask me.
and we're on page 14 now of Exhibit 2.
That is correct.
Okay. All right. Yeah, and there are a lot of teeny tiny little notes.
Page 15, I think, has plant details, so that's not going to be it. It's going to be in the general landscape notes. And I honestly, to be fair, I don't want to take up everybody's time on this call to squint.
What are you looking for specifically, Mr. Bush?
In the general landscaping notes, to talk about the tree mitigation, removal and mitigation. Oh, it's down on the lower left. Sorry. Oh, that's water irrigation budget. Sorry. I remember seeing tree retention table.
The tree retention table's on page 13.
Okay. Tree
retention.
And
does that show the replacement trees provided? There we go.
Yeah, I see existing to be removed. Oh, 10. It's even worse than I thought. And the total diameter to be removed is 205, and the total diameter inches to be replaced is 34. Preserve existing vegetation. Total diameter inches gone, 205. Total diameter inches replaced, 34. This preserves existing vegetation.
Correct.
Okay.
Without this calculation and table development is impossible.
Oh, actually, on my version of Exhibit 2, the table doesn't appear. I only have the tree retention calculations one line above it. Let me open my Exhibit 2 with a different piece of software because sometimes tables don't translate very well. I was looking at my own screen, not yours. I didn't see the tree retention table. So one moment. This is something I need to check out here. And you said page 13?
Yes.
Hold on, I'm opening it up with Adobe, which is now like bombarding me with advertisements. All right, so page 13. Hold on, now it's freezing. This is why I never use Adobe. I'll get there in just a minute. Can you make that table bigger? I'm not able to, Adobe will not open it on my computer in any kind of timely fashion. So maybe you can make it bigger. Oh, wait, I got it on mine. There we go. I'm like slagging Adobe here in front of everybody. All right. All right. And what did you want me to learn from looking at the tree retention table here?
It is a comparison of the trees that are being removed with the trees that will be planted in replacement thereof under the tree mitigation requirements.
All right. And where are the tree mitigation requirements? Is that in code somewhere?
I pause. I'm trying to remember where the city code has landscaping.
Tree mitigation requirements.
The city code has,
as we all know.
Yeah. The city code has a landscaping requirement under the old code as well as the new code.
I can jump in. It's 1812.
18.12. All right. So I don't have a copy of 18.12 that was in existence at the time of the ASDP. So I will need a copy. Just send me the whole chapter because, God knows what's in there. Just send me a copy of old 1812 and I'll take a look at the tree mitigation requirements. And who knows, maybe I'll even see something in there to the effect that, replanting 34 inches of diameter is just as good as retaining 205 inches. Maybe I will find that.
I will send it. This is Douglas Yormick. I will send 1812 to Candy to forward to you.
Thank you. I have 1804. I have 1822. I don't think I need any of the other code sections based on what I've heard until right this very moment. It turns out I probably need 1812.
Can I clarify
if you
something?
Could include everybody. Go ahead, please.
I just wanted to, because it's a little bit hard to read, it's actually 34 trees that are replacing 205 caliper inches, not 34 inches.
So it's replacement trees provided 34 trees, not 34 inches. All right. Sure. Okay. What else have you got for us, Mr. Bush?
I think that's it, but I'm scrolling through the PRJ 19-quadruple 08 for the tree removal plan, and I am not finding it.
Wait, what are you looking at?
It's the city's approval of the school district's MSP.
All right.
Is and there's
to look at
it's where the city has already, a school district, has already indicated it's going to remove those 5 trees within the 60 by 60. It was included in their tree removal count.
All right, give me an exhibit number and page number.
I am struggling to do that. Tree removal.
We all thought we saved time by having so little witness testimony, but now it comes back to bite us.
It might be exhibit 36.
All right, exhibit 36 is the landscaping plan for the MSP, I believe. Okay, and then Mr. Bush, you wanted me to, it's a 35-page document. You said there's some kind of mitigation plan in here that you want me to take a look at?
There's a tree removal plan there.
All right, page number?
That is I need to find exhibit 36 first here.
All right. Give you a moment.
Thank you. Appreciate your patience.
Oh yeah, no. This is like I said, I want everyone to make the best case they can.
I've got it up. I can share my screen if you'd
Go on.
like.
If you don't mind.
All right, so this is exhibit 36, page what now?
This is page 1, 2, 3, 4, 7, 8. It's sheet L0.7.
Page 8, L07. Okay, I'm on the same page as you. All right, Mr. Bush, what did you want me to learn from this? I see the wetland down there, the famous wetland.
And I'm going to move this to a larger monitor so I can see it better.
Please do.
I'm trying to get it oriented, a cabinet and tower.
They're not shown inconveniently. Ms. Brown ran into the same problem you did, Mr. Bush, which is it's hard to find a document that that has everything we need in one place.
Right. And
I mean, at this point, I could practically draw the site plan myself from memory. So I'll just call up Exhibit 2 for the site plan of ASDP. And I'll just do my best to compare them side by side. Page 13. Yeah.
I'm doing my best to do a split screen with the two
Yeah, I
plans.
see that. Yeah, thank you. The scale is slightly different, so the trees are different sizes. They cut off in different places, but even with those limitations, even so, I think I recognize some of these little trees. Oh, there, that's a pretty good scale.
I can zoom in further if needed.
No, this is good. This is good. Look at poor Mr. Bush trying to match it. The trees don't quite match up, do they, Mr. Bush?
well, I'm trying to identify the lease area boundary. That's my challenge. On the right-hand side of the screen.
No, I know. You have to do it based on the curve of the road.
Okay, thank you. So I'm not accustomed to reading the drawing on the right.
Yeah.
So I'll work through it with you. My assumption is that those trees marked with an X on the right side, the black X, are going to be retained.
Oh, you think retained?
Yeah.
No, I'm afraid you're wrong because Exhibit 36, which is the one on the right, has a legend, and it says if there's a black X, that's existing tree to be removed. Every black X on the right is to be removed.
Okay. Well, so now I'm interpreting on the left. So on the left of the X's are what the city plans to remove outside the compound.
Luckily, Exhibit 2, which is on the left, also has a legend, which I can look at. The black X's are trees marked to be removed on separate permit. And then it gives the permit number, and lo and behold, it is the master site plan, PRJ 19-00018. So on the left, black X's are getting removed under the MSP, and on and red X's are existing trees to be removed, but it doesn't say, presumably as part of the current permit. So I don't think you're right.
Okay.
Is what it boils down to. I think
I'm with you on that.
Black X's is what the MSP was going to take out. Red X's is new stuff that you're going to take out. That's how I interpret this.
There we go.
Yeah. So,
and
that didn't quite work out for you.
Well, but going to the left, and thank you, we can get rid of the screen on the right, Doug, so we can see the screen on the left better. So inside of the compound, there are 5 black X's.
Yeah.
trees that the city had planned to remove. And now I'm corrected to show that I'm counting the red X's 1, 2, 3, 4, 5, 6, 7, 8, 9.
Yep.
It looks like there's one. Number 10 would be under what looks like the generator
You're right.
in the lower left.
Kind of hidden under
There's-
that one. Yep,
It's a squished X.
I got you.
So those are the 10 so the 5 are already scheduled. The 10 are red X, and we saw the table for the 10 trees to be removed to be replaced by the 34 trees in that table.
Yeah.
So taking all this into account, this is preserve a reasonable I can say this, it's late in the day, a reasonable interpretation of the code requirement to preserve existing trees on site. And this is how it plays out through mitigation.
Counting site generously as, extending beyond your 60 by 60 and basically being, the whole high school.
I would phrase it, if I was to define it, it would be the area surrounding the proposed development, whatever the reasonable distance is, because I'm hard pressed to say that something 30 acres away impacts the site because of the terrain, because of the trees.
Yep.
So it's a reasonable interpretation would be the area in proximity to the proposed development.
Yes, and indeed outside the dashed line, I see many trees that are preserved for retention.
Yeah.
All right. Anything further for us on trees, Mr. Bush?
Thank you very much for your patience.
Oh, no, thank you for yours. I know it's, it can seem kind of silly, I think, to some people that we've spent, 7.5 hours or however long, discussing a handful of trees and a driveway easement and so forth. But, this is land use. We have to apply the code, and we, sometimes we have to get pretty far down in the weeds to do it. So I appreciate you holding my hand through that. All right. Do you have anything further for me on any other issues, Mr. Bush?
Nothing at this point. Thank you.
All right. Then the last word of the day will go to Ms. Brown for rebuttal arguments to anything that we have heard from Ms. Soto and Mr. Bush. Ms. Brown, would you like a short break before we proceed with rebuttal, or are you ready to go?
Yeah, maybe 3 minutes. Good.
All right. Why don't we come back at 4:15, everybody? 4:15. Okie dokie, everybody. We are in our closing minutes of our hearing. We were just going to hear the rebuttal arguments of our appellant. There are the respondent attorneys. So Ms. Brown, as soon as you're ready, let's hear it.
Okay, here we go. Long day. First, I'd like to bring up my issue, I believe it's issue that about the easement again. Go back to that. The easement for 1997 and so forth that Mr. Bush raised, we have to remember is for a temporary cell tower site. Or no, I'm sorry, it's for the water tower. It's only for the water tower, not for that. And so that does not apply in this case. The easement agreement, the second one that he submitted, which was non-disclosed until 14 days ago, and which would have altered everything, I agree, is only to a temporary cell tower, 85 feet in height. So there remains no easement. And as a consequence, condition 1 required for ASDP has not been met.
Well, hold on, and I'm really hesitant to do this, but you said that the temporary license for access, which I assume is the Exhibit 46, you said that only authorized an 85-foot tower. I don't remember seeing a height limit in Exhibit 46. Did I overlook something?
Yes, it's in there. I think on page 5.
Page 5.
For a temporary 85.
Not seeing it on page 5 of Exhibit 46, ma'am.
I have
Sorry
pointed
to do.
it out on several occasions.
Well, I want to see it in Exhibit 46 because that was your argument. So now we have to back up your argument with some facts.
Again. I'm trying to do concluding arguments. I believe I have already backed this up with.
No, ma'am. You said that if I understood your argument, you said Exhibit 46 is for a temporary cell phone facility. Correct. You also said Exhibit 46 is for an 85-foot cell phone facility. I am challenging you to back that up because I don't see a height limit in Exhibit 46, and I don't think it's there.
It is. Site.
Yeah.
A
Exhibit
temporary communication facility, including up to 2 temporary.
Wait. Page number. Exhibit 46, page number, ma'am.
Now this doesn't have page numbers. The agreement was not paginated.
Yes, it was. On the bottom of every single page, there's a page number.
Under item 1.
It's under item 1.
I'm going to read the first line of item 1 to make sure we're even talking about the same exhibit. Item 1, licensor does hereby grant unto licensee. Is that line 1?
Yes.
Okay. Now, oh, I see. All right. The site is more specifically described in Exhibit A attached here to and made a part hereof, together with the right to place upon the site a temporary communication facility, including up to 2 temporary 85. Well, okay. Let me think about that. Because this is all about access, and they have access. Well, I think what we need to be more looking at is Exhibit 4, because you're pointing to this exhibit for lack of access, and sorry, line 4. What should I say? Paragraph 4 of Exhibit 46. You're pointing to Exhibit 46 for access. Paragraph 4 is what talks about access. And I guess what I don't see in paragraph 4 is you have the right to ingress and egress to an 85-foot tower. But if you ever build a 150-foot tower, then you don't have the right of access. That I don't see yet. Okay, well, so that's in there. All right, I've got you.
They do not. They have not met condition 1. Also, there is talk about going back to try to remediate this, if I could say, if there was a remand.
Yes.
And that would involve the Issaquah School District. And in fact, they had talked about, well, we've got conditions.
Wait. Let me be clear. A remand would be a remand of the ASDP decision. I can remand that to staff to modify that decision and retain jurisdiction over this case. So if they, if the modification creates new problems, you can come back and talk about the new problems. That's what they meant. I'm not remanding anything that would require the school district to act.
Well, if it were, tell me, you can explain this to me then. They said, we were told by the applicant that there are ongoing negotiations with the school district for a new easement.
Yeah.
We have no validation of that other than what she said.
Well, her testimony is validation. It was given under oath, but all right.
But still, that's a good point. But still, we do not know at this point what the school district is doing. They don't know what they're.
They may get their agreement with the school district. They may never. Who knows? Mr. Bush was very clear on that point. There's a lot of ways this whole project could still collapse.
So I don't think we can assume that they are going to get that easement. That's what I'm saying.
Not. So, and this is why I call the condition potentially a poison pill. If I either remand for staff to modify or else just modify it myself, because I can do that too. If I modify it myself to say, the site shall have, lawful access, whether public or private, if I write that in there as a condition, and then later on the school district, withholds that access, then they never build the thing. So that's why I say it's kind of, potentially a poison pill. So I don't know. Do you want me to do that?
I Frankly, I don't quite understand what that would involve.
Don't either. We would creatively leave it up to them. That's the beauty of it from Mr. Bush's point of view.
We leave it up to the school district.
Well, we would leave it to a negotiation with the school district and the cell phone people. And if they never came to an agreement on access, then nothing would ever get built. But that's kind of already true, as Mr. Bush pointed out, right? Like, you know, you're going to need access at some point to get any kind of a permit that lets you actually build something. So in some sense, it doesn't really matter whether I do a condition that says that or not, because, you know, in any universe, they're going to need access. And if they don't have it, they can't build. That is already true right now, today, with no appeal.
I don't think so. I think it stands on the fact that there is no easement at this point.
Well, you know, the strictest possible interpretation of variance condition number 1 is right? It said, don't issue the permit until there's an easement. And it even used the word easement, and it didn't say license or anything like that. So, you know, I think in the strictest possible interpretation, the ASDP does not meet that criterion. Okay, exactly. So point to your side, Ms. Brown, you're scoring points here. Now it comes to the hearing examiner to decide, what do I do with this? Do I affirm the permit despite its flagrant disregard for variance condition number 1? Well, that doesn't seem right. Do I reverse it and throw the whole thing out? Or do I modify it or remand it to the city to be modified? Because I can do that too. So you've scored a point here. What's the remedy?
That is your job, I believe.
Well, but you tell me what you want me to do.
I want to
do something you hate.
I would love you to revoke the whole permit, because all kinds of things that, to my mind, I'll get to trees in a minute.
But if the only issue you win on is this, you know, failure to comply with the strictest possible reading of variance condition 1, if that's the only winning issue for you, why can't I just modify it and say, all right, well, you know, at some point before you actually move dirt, you need to have lawful access, and just make that a condition of approval. It's already a requirement of the code, so in some sense, the condition doesn't add anything. But I write that in there. Haven't I solved the access problem? Either they get access and go forward and build, which is you know, they're supposed to be, or they fail to get access because the school district refuses for whatever reason, and then they never build, right? Haven't I solved the problem with that kind of by adding that condition or remanding for someone else to add?
I think you're kicking it down the road. The condition needs to be met now for ASDP 22.
Well, not if I modify ASDP 22, it doesn't. And I have the ability to modify permit. The code gives me the power to modify the permit. So why don't I just modify it to compel them to obtain access? Doesn't that solve the access problem? You know, my role here is to, you know, make sure that the code is followed. My role here is not to block projects. If access is blocking the project and I can write a condition that forces them to get access, haven't I done my and solved the problem?
Let me ask you, even though by doing that, it contradicts the need for satisfying that condition now, ASDP 22.
Yeah, I suppose it would, because you know, the condition said that they needed to do it before the permit came out, and then I rewrite the permit to say, you know, you don't need your access now, but before you build anything, you do have to obtain access. Yeah, I guess I am kind of contradicting that that permit condition.
So I won that one.
What's that? Well, but so let's say we go your way, right? And I, you know, I just completely reverse the ASDP. They can always reapply, right? Mm-hmm. They can get their easement from the school district or whatever other access they need, and send in the exact same proposal. And if that was your winning issue, and now they have their easement, you know, what have you gotten yourself? You've gotten yourself nothing. And honestly, that's one of the things that I don't understand with your appeal is, like, you know, all this fussing around over access. What do you care about the access? I mean,
I care a lot. But second, I do have another issue that they have.
Well, and hold on, but before we do that, there's another problem too with this problem. Let me call up the language of variance variance condition 1 here. So this is in Exhibit 7 to Core Document 1. Prior to issuance of ASDP 22-0007, the applicant provides their access easement to use Providence Loop as access to the lease area or revise the access location to a different location.
Precisely. Yeah. They haven't done that.
And they haven't done it prior, but I would rewrite ASDP 2207 to say, you know, find a new access location, right? You want to come in from the north or whatever your plan is, then come in from the north. But your thing would be that's still not prior to the issuance of the permit.
Precisely.
What do you think the point of variance condition number 1 is in your mind, Ms. Brown? What public good is it serving?
I don't think that's a fair question.
Well, nobody has to answer any of my questions.
I think it's
but it might behoove you to answer my questions, especially you, since you have the burden. So I'll give you another chance to answer if you choose. What is the purpose of variance condition number 1? What is it trying to accomplish?
For one thing, it is a requirement for the application.
But why? What is it trying to achieve?
It's in code. It is in the application requirements. It is a city requirement.
Yeah, but does it serve any purpose, like making sure that every cell phone tower in this city has a road to get to it? Is it trying to accomplish something like that, or is there some other purpose that it's trying to accomplish?
I am not a city official. I did not write that rule.
Fair enough.
So I don't think it's a fair question.
And I'll tell you why I'm curious about this, Ms. Brown, because if the purpose of this condition was, you know, make sure you don't build a cell phone tower that no one can get to, just make sure someone can get to the tower. If that was the purpose of this condition, then maybe I can fix it by modifying the ASDP to say, don't build the tower until you have access. Ta-da, I've achieved the same purpose, right?
No, you still have not met the requirement to have this in order to have an ASDP.
Yes, I understand that. I understand that, ma'am. I'm asking a bigger question of you. If the purpose of this is to make sure towers have roads, why don't I just write a condition that says the tower shall have a road? Don't I accomplish the same thing that this condition is trying to accomplish? Isn't that the point of all this?
I think you would have to do that in no, I don't think so.
So what is the point? What is the point of this? This gets back to my question. What was the point of the variance condition?
To meet the requirements for an ASDP. It's very simple. It's in code.
Yeah, but they didn't just write that requirement to manufacture useless paperwork. They were trying to accomplish something good in the real world. What was that good thing?
That they do need easement. Okay, you can play with that if you want. I'll let you.
All right. Yeah, and
I think that satisfied my
no, just to talk me through any issues and things that are of interest to me do not have to be of interest to you. So we can move on.
Yeah, I believe it. Yeah. The one other thing, I do believe that the questions of vegetation in at least 2 of my remaining issues are not resolved.
All right.
And again, to go back to the requirement to preserve vegetation. Remember, this is not just trees. We've sort of gotten carried away talking about trees, but this is also all the vegetation in that area. And we're talking about the only one of the few remaining forested areas on the entire 40 acres. So if that were removed, the main buffer area would be lost. So I do believe that the preserved vegetation remains as an issue.
Did you say that this is one of the only forested acres areas on the entire high school site?
Yes, and I'll get to that.
Because when I look at Exhibit 36, there are so many hundreds of trees of various sizes. right?
Or those are planned to be removed.
Many are, and some are not. All right.
If you look at the whole site, you will see that the area where these trees are being removed is one of the few areas remaining after the site has been developed.
Very well.
In fact, I would go on to say that most of the 40 acres that they were talking about, Mr. Bush was saying, well, in general, this is Issaquah, which is very treed. I would say that most of the 40 acres of the site, in fact, already is without trees. This was a college campus, and the entire interior of this area is already cleared. There are many beautiful sites, alternative sites for cell tower or a WCF that would not require 150 feet, or that could be easily located in parking lots and other areas that would be more suitable, both for the Verizon and the cell tower carriers and for the school. So the idea that this is the only site is not a good argument.
And no one is making that argument. So you're kind of fighting a straw man here.
Well, I believe that Mr. Bush said that this is it, and that they have pretty much had no choice. So just a few remaining arguments on the trees.
All right.
The red X's were the additional trees, and that dotted area outside of that is the disturbed area. They intend to have that completely, all the vegetation outside of that 60 by 60 area, vegetation removed and trees. So this is much larger than just 60 by 60. When I talk about the loss of trees and loss of vegetation.
You agree that the project site is larger than 60 by 60?
Yes.
All right.
When you look at the dotted lines, it includes also, as I've said, the trenching, 5 feet wide, the entire length down to 228. This is new trenching. And it will also require significant vegetation removal.
All right, so the site extends from the square that we've all talked about a million times, all the way eastward to 228.
Yes, and that site is trenching is supposed to be in the application materials for the ASDP. However, it was not there. There's no trenching mentioned.
Yeah, in fact, I don't see anything in the record that there will be trenching other than your reference to it right this second.
No, there is trenching in the site plan itself.
In the site plan. All right, so I will take a look at that. Exhibit 2, site plan, trenching, what page?
Don't ask me. I'm sorry, I can't.
Well, I'm sorry too, but if you say there's trenching in the site plan and I don't see it, then someone's got to tell me where it is. And since you didn't have a witness on this, it's got to be you.
We'll take some looking. This has been a discussion since the very beginning, and SEPA did not mention it. And of course, they have to have trenching to get there.
I mean, I do see, this, utility easement. Mr. Bush, you've turned on your camera. Is there you're objecting to something or what? What are you doing?
Well, I agree with your observation that there's been no evidence in the record about trenching. And she's making statements that aren't supported by the record now about trenching.
I would also point out that she did not put this in her, initial closing. This is supposed to be her opportunity to respond to you, not her chance to patch up holes in her own case.
Yes,
All right. Nothing further on trenching, please, Ms. Brown.
thank you.
I'm sorry, it does exist. This is a very big issue. And it is in my appeal, it's in my other documents. So I'd like to consider that. It also was required for the SEPA. And I know SEPA is closed, but it was not in there.
I will
So-
also remind you, ma'am, where we are in this proceeding. You have already completed your closing arguments and did not mention trenching during that time. This is your chance to rebut the closing arguments that we heard from the city and the appellant. They also did not mention trenching. So I will entertain no further argument on trenching, ma'am. You had your chance, and it is not now.
Okay, we'll take that. I was just bringing that in as a further argument in rebuttal to Mr. Bush's arguments about trees. And I was saying that it will include further disturbance. That's all I was saying. I would also I will conclude by saying also that my landscaping issues such as watering, I did not bring it up. I don't know full procedure here, but there is no plan to maintain the landscaping for 3 years as required. And so I believe that issue is still on the table, so to speak.
Well, but again, not if you've left it out of your closing arguments and are only mentioning it, for the first time here at the end of the hearing, ma'am. I'm sorry. That's not fair to the other side. And I realize this probably feels unfair to you, but I have given you a great deal of time to make your closing arguments, and I have tried at every opportunity to assist you in finding citations to the record to support your arguments. But I am not willing to let you bring up new stuff in your rebuttal to the other side on issues that weren't addressed.
I'm not sure if it's fair to introduce that procedure to me at this point, but I would ask you simply to continue to consider my issues 5, 6, and 7.
I will consider them to the extent that you have provided argument and evidence in their favor, but I will not consider them to any greater extent than that.
How do I do that if they did not bring it into their closing?
You are the one with the burden here, ma'am. If you wanted to talk trenching and watering plans, it should have been in your closing. And ideally, you should have put forward, some kind of, a witness, evidence, something. So this is not the time to rescue your case, ma'am. This is a very limited purpose that you are speaking now, and that is to rebut the arguments that we heard from the other side.
So.
And they didn't talk about it because you didn't talk about it.
And I did not know that I had to raise every issue. I thought I would focus on the important issues and the others remained in force.
Well, as I said, I will consider your other issues to the extent you have provided argument and to the extent you have provided evidence. If you haven't done very much argument and evidence, then I won't give them very much consideration.
I believe the argument and evidence is in my documentation for the appeal, for the opposition to the motion, and in my closing brief.
Then those are what I will look at.
I appreciate that. And I think that's it.
Okay.
Thank you very much.
All right. Thank you, Ms. Brown. All right, everyone. So I think the only thing I am still waiting on is a copy of the old version of 18.12 of the code, which was going to give the tree mitigation formula. So I think I was going to get that from Mr. Yormick, who's going to pass it to Candy, who's going to pass it to me. And I guess you guys could get copies too if you need it, but I don't know why you would. Your argument's over now. But I sure do. I don't think I need anything else from anyone else. So the next step, once I have that code, is for me to produce my written decision. I think I'm supposed to do it within 10 working days, but folks, I'm just a little bit backed up. I am retiring as a hearing examiner come June 1st. So I've been trying to get all my cases out before that point. And as a result, I'm like way overloaded with cases because everyone wants to, get a decision from the hearing examiner before he leaves. It's not just Issaquah. I'm joining the Growth Management Hearings Board, so I'm not going to be the hearing examiner for anybody anymore. So I'm like way overloaded on cases, and that is affecting my decision timelines. I just yesterday issued a decision for City of Bainbridge Island, and that was 16 days, and that was an appeal hearing as well. So I'm really going to try to hit the 10 days, but I'm just telling you now, it may not happen, and that's 10 working days, by the way, not 10 calendar. But I sure will try my best to do that. I'll send the written decision out to Candy. She will disseminate that to our appellants and our applicant, and I don't think there's any other parties of record for this type of case. So you'll get that from me. Thank you all for your patience today. I realize that I am the reason the hearing has gone long with my endless questions and demands for citation to every little ticky-tack point in the record. I have to do it that way because, I myself have to weigh all of the evidence, and I need to make darn sure I know what evidence is the parties are relying on. So that's the reason why I kind of drag us through that. Vague allusions to the mitigation plan or whatever won't cut it. I really like to see, the actual, words on the page. So that's the reason for that. So I really appreciate your patience with it. You might feel like, oh, maybe I didn't do a good job because the hearing examiner was asking me like a million questions and like forcing me to do all these citations. I hope you'll notice that I did that for everybody. I did it for the attorneys who've done this, hundreds of times, and I did it for Ms. Brown. Everyone gets that treatment because everyone's case has to be bolstered by something in the record, whether it's witness testimony or documents. So the questions that I ask of you are aimed at strengthening your case and making it more comprehensible and better supported by the evidence. And I want there to be strong cases on both sides. And I feel at this point that I have heard the strongest possible version of everybody's case. So you have all given me a lot to think about, and I appreciate you putting so much thought into your cases and familiarizing yourselves so well with this enormous and kind of convoluted record. Everyone's done a great job of holding my hand through it. I'd just be a mess without you guys. So I really am very grateful to our parties and our witnesses for doing all of that legwork. So with that, I think we will adjourn the hearing, and I will wish you all a good rest of your day and week. And Candy, if you can send me a download link to the audio of this, I refer back to the audio when I'm drafting my decision. So that doesn't have to be today. It's 4:45. I'm not going to start writing it today, and I've got other cases in the hopper ahead of yours. But maybe in the next day or two, Candy, if you can get me a download link to the audio, I would appreciate it. So with that, I bid you all farewell. Have a good day.
Thank you.